representing the Premier.
Thank you, Chief Justice.
Thank you, sir. Good afternoon, Judge Mudau.
Good afternoon, Chief Justice.
How are you, sir?
It's a beautiful day. I trust you are well.
I am super well.
I'm pleased to hear.
And just remind us, for how many years have you been on the bench now?
I've been on the bench for 29 years. I mean, inclusive of the time that I was a magistrate. But on the bench in the High Court for 5 years, 3 months.
Yes. And have you had occasion to act as a DJP, and if so, for how long?
No, I have not had that opportunity.
And tell us now in your own words, as briefly as you can, how you acquired your leadership and managerial skills that you hope to inject into the leadership of the judiciary in Limpopo, should you be appointed to deputize for the JP?
Thank you for the opportunity. Thank you for the question. Chief Justice, Commissioners, I have had a distinguished career since I joined the fraternity. Very early on, when I was appointed a magistrate in Toyando, there were complimentary remarks by the then Judge President of the Venda High Court Division and other judges. This I refer to in my CV in relation to how I performed my duties. Subsequent to that, I was appointed a senior magistrate in Johannesburg. A year later, that was in 1997, I was then control senior magistrate for the criminal section, which I headed about in total 47 other magistrates, including 5 senior magistrates. It is for the whole of Johannesburg. That prepared me well, because the section on its own, given the number of magistrates, if you think about it, beats any other magistrate court in the land. Now, if you look at the number of judicial officers for Limpopo, I had 4 times the number of judicial officers that I had to control. In that position, I helped the chief magistrate to run the court. This was the special grade chief magistrate, and I was involved in the day-to-day running and the management of the court. The job entailed was supervisory in nature and coordinating the functions of the various branch court with the main office. I had the responsibility of issuing rosters, monthly rosters, for the various magistrates who were to perform duties in the main court, as well as the various branch courts in Greater Johannesburg. I was in that position for 8 years. Subsequent to that, I was appointed a regional court magistrate, which position I sat for 10 years, and the managerial responsibility continued in that I was a coordinator, regional court coordinator. If I was to go back a bit to my introductory remarks, as a senior magistrate, as I said, I had to write reports, I had to coordinate what happens in reviews, appeals, between matters finalized in the district court and those that are headed for the High Court. So it was indeed a managerial position.
What contribution do you hope to make, or do you see yourself making, to reinforce or to enhance the leadership of the province? It's a fairly new division. What areas have you picked up that could benefit from your skills, from your experience, from your knowledge to support the judge president?
I had an
Just as briefly as you can.
Thank you. I had an opportunity to spend the entire term last year in Limpopo at the invitation of the judge president, with the support of my own judge president, of course, with the blessing of the Minister of Justice. So that gave me exposure, a great deal in the workings of the Limpopo High Court and its local division. I managed to see some gaps that I think I can, if I was to succeed in this role, add value in terms of its management. The biggest challenge that they have, other than infrastructure, is that there's a huge backlog, in particular of criminal cases. And more so in Toyando, I'm sure you must have had this ad nauseum over a period of time, that there have been instances where cases are not finalized. The biggest challenge, obviously, is that they don't have enough courts. They only have 3. You've got 3 judges who sit there daily, who must do everything that has to be done in that local division. What I picked up is that the allocation, or rather the role planning, as it were, when one has regard to the transfer of matters from the lower courts to the High Court, as intended for summary trials in terms of Section 751C, is done a bit poorly, in that all matters invariably are given only 5 days. I checked the roster and I realized that it's almost well-nigh impossible to go through a matter, rather a trial, for instance, that involves capital offenses such as murder, rape, you name it, and you've got about 31 charges and you've got numerous witnesses. And you know, for instance, I asked for those the rosters. They were sent to me. I was able to analyze. I picked that up as a matter that I thought one can add value. My suggestion would be to come up with a first appearance court to ensure that when a matter is postponed for trial, all the parties are ready for trial. My suggestion in support in this regard would be that when matters are referred to the High Court for summary trials, it should be for a specific date. If I succeed in this position, obviously, I would suggest to the JP that I sit in that court, given my experience over a long period of time, so that when I say the matter is set for trial ready, it is indeed trial ready, in that all the parties would be ready. That is the biggest downfall in my view. Secondly, Chief Justice, Limpopo High Court, and it requires judicialization, case lines. I am in a province where I hardly ever see my colleagues, but yet you will sit in motion proceedings, in appeal proceedings, you name it all, where cases are, running. And thanks to my judge present, who's here, who introduced this, it's working. So I will be able to introduce it with speed and promote it with the JP and the rest of the colleagues, because that is where the challenge is. In other words, in as much as you may have only 3 judges, but I don't have to sit in Toyando in order to run the trial. For instance, this week, I was able to sit at 8 o'clock in the morning, at 8 o'clock at night, and in fact, I'm in a criminal trial role to deal with applications for leave to appeal. So it is doable. That way you'll be saving expenses, not only for the litigants, but also, it's more convenient because files are not lost, they are online. So that is one innovation that I'll be willing to bring aboard. Another factor that I think I can play a role on, I've experienced situations where, in particular in criminal matters, where when applications to appeal further has been entertained and someone who has been convicted now has been given leave to approach the next court. There are gaps in the system, in that you'll find that if the appeal is lost, I've experienced personally where a person eventually died without having served his term, whereas and in fact the appeal has been lost. I will be suggesting that there has to be a task team that involves the relevant role players, you name it, correctional services, NPA, a member, myself or someone from the judiciary, to ensure that if you are given an opportunity to prosecute an appeal, you don't do that. We must interrogate what is happening so that eventually, if there's no more interest to appeal the matter, then the person must serve. More often than not, you find that records from the lower courts are incomplete for purpose of appeal when they come to the High Court. Why? Because the data would have been lost. But if you have such a structure in place, the system cannot be abused as it is currently abused. So those are some of the initiatives. The list is not exhaustive, Chief Justice. If time permitting, I can add more if you permit me.
Felix, let me just have your name so that and then there is none. Very well. JP, again, I apologize to you for saying you are Lahodi, man. I really apologize, my brother. Over to you, sir.
Thank you, Chief Justice. Good afternoon, Judge Mdau.
Good afternoon, JP.
Judge Mdau, last year, 2020, you had an opportunity of coming to Limpopo to sit as a judge there with the blessing of your Judge President, Justice J.P. Mlambo. And most of the time you spend the time at the main court, the main division in Polokwane. What were your observations there in respect of the running of the matter, in particular, even civil matters, or even all the matters for that matter? And your observation, and what innovations would you bring forth were you to be part and parcel of that division?
Thank you, JP. When I was in Polokwane with you, I said in appeals, I dealt with mental health matters, rentals. You allocated to me, JP, you'll recall, very lengthy, outstanding criminal court matters. As I indicated in my introduction, I thought the one matter, for instance, that I dealt with last, which captured media attention, was meant only for a week. As it turned out, it was more. I had to come back to my own JP to ask for more time. I came back during the recess period to continue with the matter. However, the prosecutor was also involved before another colleague in a matter that has been running for the last 5 years, as you may recall. I had no option but to request my JP to release me for an additional 10 days after consulting with the parties. But one day when the building was closed down because of COVID challenges, I managed to finalize that matter in 8 days. Now, you asked me, what were the challenges? I realized, for instance, that people are a bit like a rascal. So in my court, I made it clear to the legal representatives, to the orderlies, to everyone involved in my court, that I would not allow that. If I say I adjourn the matter at 9 o'clock, for 9 o'clock rather, or 9:30 a.m., that would be the time. So I think the word, my presence and the word quickly spread around that in that court, this firmness. I was fair, I was firm. So that is the one area that I noticed. As for appeal matters, JP, my one regret I noticed is that when I took over some of the appeal matters, there were no heads. And I thought, that is a bit unfortunate, because you might end up with a huge appeal matter, but you don't know what is the appeal all about. Is it, if it's civil matter, is it quantum? What is this? Do you have to read the whole record? So that is the one issue that I thought needs to be looked at, which can be easily be resolved by, an appropriate amendment to directives in relation to when heads must be filed. I thought to wait, unfortunately, for a busy division such as yours, would delay the hearing of the appeals. Thank you.
Further question, Judge Mudau. You are in Gauteng. Gauteng courts are modernized or digitized in respect of motion and as long as trial matters. As you are aware, in Limpopo, we're not yet connected. There's no connectivity. We have not yet gone on digital or on case line. Now, with your experience from Gauteng, if you were to come to Limpopo, how would you go about orientating your fellow judges to get into this new modern technology in respect of a hearing of the matters?
JP, in that respect, I will hit the ground running. In as much as when the program was introduced about 2 years ago, thereabout, one had questions with regard to, will this work? Will this not work? We have seen the benefits. The benefits are that you don't have to wait for a file. The benefits are that everything is on case line. The benefits are that you can receive heads of argument autonomously. The benefits are that you can communicate with the parties even in the middle of the night if there are certain concerns that you've got. The benefit are that there are no undue delays. So I'll definitely be promoting this with I can't wait. This is the way to go, more so because the division, particularly Toyando, has got no infrastructure. So in the event, for instance, you were to invite some acting judges, they don't have to go and sit in Toyando. They can sit in the benefit of their libraries wherever they are to connect in, because in as much as the building itself has got Wi-Fi connectivity problems, my chamber, if I recall, was next to yours. I had no problem with connectivity, meaning that it's certain floors, certain offices, basically, where there are problems, but one can rearrange that and identify spots in the building where you can run a civil trial, motion court proceedings, appeal proceedings successfully. So a connectivity problem, I think, should be a small errand to sort out.
I thank you, and thank you, Chief Justice.
Thank you very much, Judge President. Mr. Singh.
Thank you, Chief Justice. Good afternoon, Justice Mudau.
Good afternoon, Mr. Singh. All right.
You would have heard the adage that justice delayed is justice denied. I see on your application that you have 3 reserved judgments. Tell us as to the status of those judgments as of today, and if they're still not completed, why is it so?
You can be rest assured that it was only because I had not yet delivered the judgments. And even then, they were not delayed judgments, I must point out. They were not. Those judgments, you'll find them on SAFLI. So they have been delivered. I owe no judgment as we speak. Not a single one.
No, thank you for that, Chief Justice. That is all.
Thank you, Mr. Singh. Your excuse, Judge Mudau.
No, Chief Justice. Oh.
I called for names.
No, you didn't. No, you didn't.
No, CJ, you did, but we could not hear you properly.
Well. Give me your name.
Julius.
I said before I call Judge President Makoba and Mr. Singh, may I have colleagues' names? And
Julius.
nobody said anything. I said, oh, so there is no name. I'll write it down, Honorable Malema. And Honorable Minister, I heard your voice as well.
And Dodovu. Yeah. And Dodovu.
Yeah. No, CJ, I'm confirming that you did call, but there was a technical problem. That's why I could not hear you clearly.
Okay.
Yeah,
there must have been.
Yeah.
There must have been.
Baba.
After Honorable Nyambi, who is next?
Baba. Honorable Cyril Baba.
Honorable Baba. Yes. Thank you so much, Chief Justice. All right.
Type CJ.
Yes.
Bernard.
Yep. Okay, Bernard.
Lucas.
Thank you. Any other? Thank you.
JP Mlambo.
Okay, JP.
Sigogo CJ.
Honorable Malema.
Sigogo CJ.
Honorable Malema, over to you, sir.
Thank you, CJ. Thank you, Judge Mudau. Have you ever been to Thohoyandou since you're acting in Limpopo?
Yes, I was there.
You did court in Thohoyandou.
Not only that, I was there a few weeks ago. I toured the High Court. I had an appointment with the current.
Judge, I think speak into the mic or
Thank-
position it in such a way that it will capture
Thank you.
your voice,
Thank
because
you.
the likes of President Maya won't hear you.
Thank you, CJ. I was giving an assurance to Mr. Malema that indeed I've been to Thohoyandou. I go there often because that's my home province, one. So I went to Thohoyandou High Court. I had an appointment there with the current acting Deputy Judge President Homo. It was over a weekend. It was on a Saturday in particular. He took me through the entire building. I made observations of my own. I knew the building before, but I had not been there for some time. I hope that answers your question, sir.
No, I'm asking, have you done court in Thohoyandou? That's what I'm asking.
Fair enough. I haven't done court in Thohoyandou.
Do you have a problem doing court in Thohoyandou? Because I heard you giving example that this digital courts will help because Thohoyandou, there is a problem of building. You can do Thohoyandou being in Polokwane.
I have no problem in sitting in Thohoyandou. I started working in Thohoyandou, so I have no issue whatsoever in constituting a court at the Thohoyandou High Court.
So, Judge, why when you were asked about your years on the bench, you said 29 years and then self-corrected and said 5 years? Is there a difference?
I had to clarify that. It's a magistrate court bench and a high court bench. When I said 29 years, that was inclusive of the time that I spent in the lower courts.
Did you do civil case when you were acting in Polokwane?
Yes, I did. Some of them are on Safli.
Thank you.
Thank you, Mr. Malema.
Honorable Minister.
Thank you, Honorable CJ and Wumdao. Maybe to take it from where Honorable Malema ended.
Yes.
On the 29 years and that confusion. Do you consider magistrates as being part of the judiciary?
They are indeed.
So maybe that is what caused that, where you are not sure whether it's 29 or 5 years.
I am very sure. So that is why I mentioned 29 years. I was just doing it for the benefit of those who need clarity.
Oh, okay. The issue of rationalization of our courts from time to time become a very difficult issue for us with the leadership of the judiciary, particularly on the acting appointments in the various divisions across the country, because it has become clear that Limpopo and Mpumalanga, they've got serious difficulties in terms of the size of the courts, unlike the other ones. What has been your experience since you have been to Limpopo with regards to the work backlog?
The work backlog, Honorable Minister, is huge. I spoke to the current Director of Public Prosecutions to have a sense, because I had to promote some of my ideas. For instance, the first appearance court or the certification court, I had to hear her views in that regard. She told me that when she started there, she only had 23 cases, but they also have ballooned, as it were. So there's a lot of work. I have spoken to the current regional court president. I spoke to the chief magistrate. This flows obviously from the concerns that the chief justice had in my last interview. So this time around, I had to do that. And each single one of them complained that unfortunately the work has ballooned. You will be shocked, by the way, Minister, by gender-based related violence cases. They are some of the worst that I've ever seen. Now, if those cases are not pushed and resources are not committed, unfortunately, it has got serious implication for the rule of law and also for people losing confidence in the way we do things. So To give you an example, I spoke to a regional magistrate who sits in Guyana. He must sit 2 weeks in Guyana and another 2 weeks in Sukmekar. The distance is about 150 kilometers odd, he told me. So imagine when he's in Sukmekar, the work in Guyana is falling behind, as it were. So that is some of the problem. Limpopo is a huge province, and the infrastructure has not been extended. You look at the Tondo High Court; it was built for the then times. Nothing has moved. The High Court itself has got the DP staff, the master staff, the state attorneys in one tiny little building.
Yeah, maybe CJ, with your indulgence, last follow-up.
Yes, Honorable Minister, please.
So how will your appointment help with that difficulty that the division is having in terms of this lack of the judicial post that meets the backlog?
Minister, I am aware that the resources, there's a lot of competition in relation to state resources. My approach, as I was at pains to indicate, is that with case lines functional, if you remove, for instance, your appeals from Toyando, any other person, your motion court proceedings, and you're doing them online because you can do those. You don't need a physical court to do them. Anyone can sit wherever they are. You constitute a court. Obviously, this will also entail, Minister, that we have to identify very, very old cases, because I know you are amenable to appointing, if properly motivated, an acting judge to sit over those very old cases, as you have done over the last few years, period of time that I've picked up. So one will have to identify very, very old cases so that we find acting judges to come in and help, and that way deal with the situation as best as we can.
Thank you, CJ.
Thank you, Minister. Honorable Dodovu.
Thank you, CJ. Good afternoon, Justice.
Good afternoon.
You have applied for a management position, and my question will test your capacity in terms of management.
By all means.
I visited the Polokwane High Court 2 years ago. Well, what I picked up is shocking. It was built in 2010, but there are serious problems in terms of the infrastructure of Polokwane. For example, the budget was 133 to construct it. It ballooned to 1.1 billion. Still, maintenance of issues like geysers, like water, like lifts at that time were not working. If you are to be afforded the opportunity to fix that or link to that, the department was informing us that there is an investigation, the SIU investigation taking place to investigate what happened. I don't want to take you to the history of that. The information is available. But if you were to be given the responsibility to resolve the problem, how would you go about doing that?
Thank you, CJ. Thank you, Commissioner. You would have heard from previous interviews, I remember Mr. Meller complaining that another big problem with Polokwane is water provisioning. I inquired, I was told that it has to deal with, they've got tanks on top of the building. However, there's a problem with a pump. I would imagine that to fix a pump certainly should cost a little bit less than, to deal with the entire building. Because if there's no water provisioning, you are talking about human rights. After 2 days, a day, you can't be using a building because you can't use a bathroom, for instance. It becomes a problem. I've experienced that personally when there'll be no water, but it's a different situation when you've got access to your own private bathroom. But for more than 48 hours, it becomes untenable. So, as you said, there's investigations going on. That is obviously beyond us. But to fix a tap, or rather to fix a pump, to fix that, my responsibility to knock at the responsible doors that please attend to the pumps.
Yes. Lastly, to CJ, one of the biggest problems there is communication. As you know, Limpopo is a poor province. People travel long distances from Sekhukhune and elsewhere. How would you improve communication between the court and the communities in its area of jurisdiction? Communication.
The courts communicate through judgments that we deliver, that are, that we preside over. In instances where there are community activities rather, where it is appropriate for a judge to attend, I will have no issue in attending those, to address whatever platforms I can in order to alleviate challenges for people to be able to understand how things run in our division.
Thank you, CJ.
Thank you, Honorable Dodovo. Honorable Nyambi?
Thank you, CJ. Afternoon, Judge Mudau.
Good afternoon, Commissioner.
I'm taking it from where Honorable Dodovo left it. The issue of the position you have applied for is a leadership position.
Yes.
So if you can share with us the current immediate challenges facing judiciary in the country, given your 5 or 29 years experience.
I need clarity. Do you mean facing the judiciary countrywide?
Yes, I'm talking about the country.
Thank you, Commissioner. The current challenge from where I sit as I look at things is that the judiciary is under attack, immense attack. When one looks at social media, recently, I must add, it is a very important arm of government. If it's broken and we allow it to break, that will be a huge threat to our democracy. That to me is a challenge. So I think it behoves all of us so that we do our bit to ensure that we do not attack it unduly. I'm not suggesting for a moment that judges are beyond criticism. I'm suggesting now, as I hereby do, that when they are, criticized, it must be informed criticism. So that to me is the biggest challenge. I hope I answered you.
Let's take it further and you explain a classical case where you'll be saying the attack is fine, because you have tried to explain that, but you never use an example so that we can be on the same page. I don't want to assume we're understanding each other.
Recently, there has been in public platform and in social media suggestions, for instance, that the judiciary is captured and words to that effect. And that, to me, obviously, if there are such suggestions and they are not investigated thoroughly, it leaves a wrong impression. People will start doubting whether the judiciary indeed is independent. That is the one example I can think of.
I am seriously mindful of time. Thank you, Judge. Thank you, CJ.
Thank you, Commissioner.
Thank you, Honorable Nyambi. Honorable Baba?
Thank you very much, CJ. Good afternoon, Judge.
Good afternoon, Commissioner.
Thanks. Notwithstanding your senior positions at magistracy, you have not acted at senior level at High Court. And you also have not been invited to act at SCA. In your view or opinion, does this count against you being given a senior position at like the one you have applied for? Thank you so much.
Not at all, Commissioner, because I have had a lifelong experience of leadership. So that experience is not lost. For instance, in Jurist, I served in the provincial committees. I served in national committees. I serve in committees in my own division. If I were to take it a step further, respect is earned. I have earned my strap in terms of respect from where I come from. If I was to give you an example, for instance, I am often invited to give talks, to give lectures in relation to aspirant judges. That alone is a recognition. Now, if you look at my positioning in the division, I am at 47 when one has regard to the beginning of the term. But there are a number of judges who have since left, given that they were here, and meaning that that number, that seniority has been reduced. Locally, where I sit in Johannesburg, I am at number 22. So if you remove a number of those, meaning that I'm in the top 20 of the judges that are in Johannesburg, can I take it a step further? I am often allocated work to sit and preside over full court matters, which involves judging the work of another judge. In other words, presiding over a matter that involves 3 other judges, and I'm presiding. A few such matters this time. I've done it often. So that is not a small role. And that certainly would not take away anything. I mean, either you have it or you don't, and I do.
Ngiyabonga, SJ. Ngiyabonga, Judge.
A small
Thank you,
follow-up,
sir.
CJ. Just a very small follow-up, if you don't mind.
Okay, JP. Yes, go ahead.
Judge Mandau, you say in Johannesburg you're number 22. If
Yes.
we were to slot you as one of the judges in Limpopo, what number would you be?
Currently in Limpopo, there are only 3 judges who are my seniors. 2 of them are retiring next year. Other than the JP, I beg your pardon. Other than the JP, is Justice Homu, is Justice Patudi, is just Makafula.
Thank you.
Thank you, JP. Commissioner Tsepe.
Sorry, CJ. Just a quick follow-up.
Yes, sir. Please go ahead.
Yeah. Which Judge Patudi is your senior?
The one who's not here. The one who was here in 2019.
The one in Toyando?
Yeah, that's right.
Okay.
So the one who's here today is my junior.
Okay, thanks.
Commissioner Tsepe.
Thank you, Chief Justice. Good afternoon, Judge.
Good afternoon, Commissioner.
Judge, I know you haven't acted as a DJP in Limpopo, but I just wanted to find out from you while you were there, if in your view you came across any challenges in the division relating to allocation of work, and if so, do you think you could propose any system to deal with allocation of work to judges for their optimum exposure?
Let me preface this by the following. In my previous position as a magistrate, I allocated work to 42 magistrates in Johannesburg. So that comes, and I spent 8 years in that position. I would allocate a court and work and identify strengths and weaknesses of each individual judicial officer to say you're strong in drugs, you're strong in this one, and so forth and so on. So that certainly won't be a problem. By the way, if I'm a senior judge in an opposed motion court role, which often happens, where I come from in Gauteng, often we are 4 judges to do in a week opposed motion role, and it has happened often where I'm a senior judge, and I will allocate work, as I've often done, to junior judges. I sit often as a senior judge in urgent court matters. I did that towards the last term, and I'll allocate work to a junior judge. So it is part of how things happen in a busy division such as mine.
Thank you, Judge. Just the last one relates to, I heard you talk about how timelessly you deliver your judgments. Do you think there may be challenges in Limpopo regarding timeless delivery of judgments, and how would you, if there are, how would you propose to capacitate judges and introduce interventions to enable them to meet this, if those problems exist?
It is a fair question. When I was in Limpopo, I led by example. When I left there, all my matters were finalized. The very last day of the end of term, I sat with the judge present in a full court and in a full bench court with the judge present. He didn't have to ask me for a judgment. Those judgments were delivered within days. In other words, I have been exemplary, and and I'm sure. And by the way, my colleagues were pleasantly surprised at the speed at which I finalized cases. So that alone, it's a gospel on its own, because there's work, but the work needs to be done. There's work, the work needs to be done. Going forward, obviously, this would entail engaging them, having meetings, and coming up with strategies as to how best to distribute the work. The issue I gave as an example, the huge criminal court roll in Toando, I'm willing to go and deal with some of the cases. I've got no fear of that. And I would want to see those cases finalized if I have to sit in those courts.
Judge, thank you, CJ. CJ? President.
CJ is here, Commissioner Table.
Are you done, Commissioner Tsepen?
CJ, many times I kept on saying, thank you, CJ. I was going down the line.
No, there was a little glitch. Commissioner Barnard?
Thank you, Chief Justice. Judge, I just want to clarify, is there one SPAR group versus Nedbank, or two matters with that name?
I could not hear the question accurately.
Sorry, I just wanted to check, is there two matters with SPAR group versus Nedbank, or is it the same matter that was reserved and part heard?
There's only one matter, and I can give you an assurance that that judgment has since been delivered. It's 26 pages long, typed. You'll find it on Safely.
Because you indicate on page 31 of your, what is that page of the bundle, page 31 of the bundle, you indicate that on 28 September you reserved judgment, which obviously since has been granted. But then remember, you filled out this form in November, and in November you then said the SPAR group versus Limited and others waits allocation for argument on merits and availability of counsel. So I just wasn't sure if that was maybe something in addition to the previous. Sometimes these matters have various angles.
No, I only had one commercial matter between the SPAR group of companies and Nedbank, and that matter, I repeat, has been handed down. I owe no judgment.
Thank you, Judge. Thank you, Chief Justice.
Thank you, Commissioner Barnard. Honorable Lucas.
Thank you very much, Chief Justice. Good afternoon, Justice Madao.
Good afternoon, Commissioner.
I don't know how to preface my question because it's two prefaces. But you have indicated that you've got a very high number of gender-based violence cases within the Limpopo division. That is what you have said. My observation is that Limpopo have been, I think in 2019 we've been here, but we were here, and there was a challenge with regards to the allocation of judicial officers to Limpopo, which it seems as if they've got a very small allocation of judicial officers. In that context, if you successfully are appointed into the leadership position that you are applying for, how are you envisaging to, with the existing challenges, to address the specific areas, particularly the one that you have highlighted, because it is of interest to myself? Thank you.
My immediate program of action would be to list them in order of age. In other words, since when were they reported? Because you don't want a situation where a victim of gender-based violence cannot be traced anymore, because then the case is over and you'll have someone, free, going through the communities, repeating the crimes that they allegedly committed. So it will be to identify those, list them in order of age, and approach for a slot if we can properly motivate for acting appointment. There are many competent magistrates and practitioners, by the way, who can sit for short durations of time to accommodate those. In Polokwane, we still have some office space and courts that can sit. In my discussions with the DPP, she said to me it would not be a problem to transfer those cases, rather to transport witnesses and accused to Polokwane, if those matters, some of them are short, for us to accommodate those trials in Polokwane because of the infrastructure challenges in Toyando. So that will be my mission.
Just the second question that I want to ask, I hear what you say. I would have also recommended that you possibly work with all stakeholders.
I beg your pardon?
You possibly work with all stakeholders in addressing the specific issues, because when we had our consultation with Limpopo, the Commission of Gender Equality and the Premier's Office and others, we actually urged them to form a kind of a committee that will be able to deal with these issues, and it can assist very well if, as you judiciary, you can be part of that body. But I think, let me not elaborate on that specific issue. Just lastly, if you go there, you have not been a permanent fixture of that specific division or jurisdiction. And now what do you actually, if you get appointed, how are you going to approach the issue of being accepted or the kind of cooperation or lack of cooperation that can possibly be there? I mean, any person that are coming from somewhere will be seen as an outsider. But how do you envisage to approach that kind of challenge?
Commissioner, let me give you an assurance that even the first time around when I presented myself, I had majority support of sitting judges in that division. Even when I'm here, I give you that assurance. It's a very small world. We know each other. I've worked with the two candidates that are going to be interviewed after me. We are friends. We are colleagues. I have interpersonal skills. I relate well with most people. To me, it's about the job that needs to be done. Even if we disagree, can we please disagree with respect? You don't have to agree with me in every decision that I make. You may disagree, but let's do so civilly and let the work be done. Anything else is a distraction. We don't need it.
Chief Justice, we'll leave it there. Thank you very much, Justice Mudau, and thank you.
Thank you, ma'am.
Thank you very much, Honorable Lucas. Honorable JP Mlambo.
Thank you very much, Chief Justice. Two questions, Judge Mudau. One, I want your views about this statement that as a leader in the judiciary, you don't only have to be a leader in management and administration, but also as a jurist. What's your response to that statement?
Thank you, JP. Obviously, we all bring different traits to the work we do. Some are strong in other areas, some are, weak in other areas. But given this position, obviously, one has to be a leader, I think, and try in all fronts to make this exercise work, because you've got a huge responsibility. You'll be supporting the judge president as the head of that division. So there are areas of interest where you have to show your leadership skills for this for the work of the judiciary, to be a success.
Thank you. Just as a follow-up, it's not my second question, it's follow-up. Have you written any judgments that have gone to the SCA and been upheld, and maybe gone to the Constitutional Court and be upheld?
As a matter of fact, I have. I was the last time when I was here, there was a matter of Magnet's trust judgment involving trustees. A full court, in other words, 3 judges in my division, shot me down, and recently, on the 23rd of October 2020, the SCA redeemed me. So, in other words, my original order stood, and I was pleased because the order that upset my judgment, the bench rather, 2 of them were my senior colleagues, and only 1 of them was my junior. So imagine if you are, how edifying it is to know that you can stand your ground and that you're wrong, not wrong on the lowest way. That is the one part. I've been taken to the CC, where I declared a mistrial and ordered a retrial in the Constitutional Court. So yes, I've been tested. I only have 1 single judgment as I sit here in front of you, JP. You should be proud, in which I was not, wherein I was upset. Otherwise, as I sit, I don't have any other judgment where I was upset.
Thank you. My last question. With your regional court experience and as an aspirant leader in the Limpopo division, one of the responsibilities of a judiciary leader like JP and DJP in the JP's absence is to chair the PEEC. The perennial problem in South Africa are the awaiting trial detainee cases in the regional court that are not finished. Some go up to 8 years being parted and not finalized. What do you think you could do to address that problem in Limpopo if you are appointed as DJP?
JP, I'm pleased you are asking this question. It is the answer I give you. It's linked to the original introductory remarks that I made. I think not enough focus is given to the way that the work is allocated. I started a trial this week. There are 38 counts involving gender-based violence, rape, numerous rapes, by the way, by an alleged serial rapist. The days allocated for that trial, it's 20 days. I said to you when I started to introduce the topic that in Limpopo, particularly in Thohoyandou, each matter, irrespective of the size of the matter, the number of complainants, capital crimes being involved, rape, you name it, robbery, aggravated, you name it, they give it a week. So my approach would be, JP, to come up with a certification court to be involved in the role planning. In other words, do your transfer for a summary trial in the High Court, but the moment it lands there, I'm going to ask the JP, can I sit so that when the role is planned, I have a firm and an active hand as to how can these matters be dealt with in an expeditious fashion. I was deeply concerned when the DPP gave me examples that there are instances where one case was postponed 180 times, in another instance 160 times. So there's something seriously wrong. Something needs to be done. And I'm sure I can add value in that regard.
Thank you, Judge Mudau. Thank you, Chief Justice.
Thank you, Judge President. Commissioner Sigobro.
Thank you, JP. Thank you, CJ. Sorry for that, CJ.
Don't worry, I was a JP before.
Thank you. Judge Mudau, how are you?
Good afternoon, Mr. Sigok. Commissioner Sigok.
Thank you. You are contesting for the position of DJP being 3, 2 males and 1 female. Limpopo Division of the High Court has 1 female judge.
That's a fact.
And Limpopo's JP is a male.
That's a fact.
So I'll want you to assure this commission that an appointment of a male candidate to that position where we have only one female judge with a male JP will augur well to the transformatory agenda of the judiciary.
Thank you, Commissioner Sigogo.
Maybe let me complicate it further, Judge Modawe, and say the vacancy was created by the appointment to the SCA of a woman who used to be deputy.
That's correct. I'm aware of that. And I can't forget the question that was asked by Commissioner Malima 2 years ago. He kept me busy there on that aspect. Let me start by the following, and please bear me out. When I arrived in Johannesburg in 1997, this was 3 years after 1994. I arrived in an office which was predominantly white and Afrikaner. I took up a position and replaced a male Afrikaner who was 55 years of age. He was boarded because he went mental by my arrival. I was young and he could not take it. I embarked on a process to transform that office. I am pleased to tell you, because I spoke to Justice Karalse, whom I had identified and invited her to come and serve. She was a prosecutor, but I played a leading role in identifying her and many other women who are now serving in the judiciary. Not only women, behind me in the course of the next few days, you'll be interviewing people that I had identified in transforming the office. A number of them, I don't have to mention names, there are at least 3. So to come back to the issue that you asked me, if I was to be appointed, that's not an end in itself. None of us are here to live forever. Next year, 2 judges are retiring. I'll make it my mission. In fact, I gathered already that the JP sent for training in March 2 aspirant judges whom I was told in confidence that they are ready to be appointed, 2 women. And you can be rest assured, I'll be taking it up if I go to Limpopo, I'll be taking it up with him that no, we can't sit only as males. So it's not an end in itself. In fact, if you look at 1741B, which is the subject matter of your question, as enshrined in the Constitution, it is not phrased in peremptory terms. It says consider. So in other words, you've got a female candidate waiting to be interviewed. By all means, if you find a fit, I can't be in the way. I'm just going there to do what I've been doing for all these years. To me, it's service. I enjoy the Gauteng division of the High Court. I've made friends. I've made it my home. I'm highly respected. I'm highly appreciated by my colleagues. To me, I'm just going back to another province to do the best I possibly can, given the whatever number of years that God would grant me. So that you can be rest assured would not be an issue. If I sit in that position, remind me in 2 years' time, what have you done? What is this? What is that? I've already told you, 2 candidates, women, are in the wings.
Thank you for your answer. And I should assure you, I know where you stand in transformation. So that's why I wanted you to clarify that to the Commission. Thank you.
Thank you, Mr. Skok.
Thank you, CJ.
Thank you very much. Thank you, Judge Modawe, you're excused.
Sorry, CJ, may I just ask a following up question? Sorry, my
Sure.
name wasn't on the list.
Sure.
Good afternoon, sir.
Good afternoon, Commissioner.
I would just like to know from you, you said quite with conviction that the SPA matter that you initially indicated on your questionnaire was handed down and can be found on SAFLI.
Yes.
It's not there.
Is it not there?
No, it's not there. And my question is, to what extent can you rely on SAFLI to publish your judgment so that you can say this with conviction?
If it's not there, I apologize. I directed the librarian to put it on SAFLI, and I'll tell you why. Initially, and by the way, this was a highly contested commercial matter. The parties had, against whom I found, had indicated that they were going to appeal. Guess what? They have abandoned that. So the appeal, the judgment stands. I can assure you, I've got my computer with me. I can forward it to you now. The judgment is out there. It's not on SAFLI. I'm going to make a follow-up with the librarian. What's happened? It's not every day that we check, but I had directed that, please, that judgment should be at least be on SAFLI. I'm sorry about that. I didn't mean to mislead.
No, I didn't think you misled. No. I was just not sure how things ended up on SAFLI, because sometimes we don't find cases that are handed down on SAFLI. And that's why I checked.
The practice with us is that once, in my division, once a judgment is handed down, it's a public document, you send it to the library, whether it goes on to SAFLI or not. There are many, many judgments. I'm sure the JP will bear me out, which we hand down, but which form the database of the division. There are many, many judgments. So that one, I made an assumption because I had in fact directed that it must be by way of email. So I made that assumption, and I thought that's where you'll find it. But you know, I'll make a follow-up on that.
Thank you, Judge. Thank you, CJ.
Thank you, Prof.
Thank you, Prof. You're excused, Judge Ndau.
Thank you for having me.
The Chief Justice, the candidate is ready.
Good afternoon, Judge Paturi.
Good afternoon, Chief Justice.
How are you, sir?
I am together, and yourself, Chief Justice?
I'm very well, thank you.
Yes. It's like...
yes.
No, I was just saying I'm well, but coming here, as you know, is like walking.
Not easy.
It's like walking the 52 steps towards Calvary.
Okay. No.
It's not that easy. It's not that easy.
You are a very strategic man. You are a very strategic man. Anyway, Judge, tell us, how many years has it been now on the High Court bench?
In July of this year, it will be exactly 5 years as a judge.
And have you had the opportunity to play some leadership role, whether at a committee level or at any level, whilst a judge of the High Court?
Yes, indeed, Chief Justice. I have, for 2 terms in succession, the beginning of February 2019 to the last day of June of that year, I've been acting as a Deputy Judge President, Limpopo Division.
And tell us how, as a judge and as acting Deputy Judge President, you were able to equip yourself for this position that you're applying for? How that opportunity enabled you to identify the challenges, reflect on the solutions, and actually identify possible solutions to the challenges that confront the division?
Yes. Whilst acting as either a judge or acting judge president, I had occasion to interact with the magistracy in almost all districts, ranging from Musina to Bilabela, Palabora in the east, and Lepalale on the west, including from Polokwane downwards to Bilabela. The challenges that I've experienced are mainly infrastructural in nature, in that most of these, the courts, the district courts, actually have dilapidated infrastructure because they are old courts which were established way back during the homeland system. And some of them were built by the previous regime prior to the establishment of national states authorities, that is the homelands. Now, they are old. Some of them have leaking pipes, and electricity most of the time fails because of the old cables, which are more often than not destroyed by mice. I know for a fact that a court in the local division of the High Court in Tohayando, for example, was gutted by fire, occasioned by failing old cables, electricity cables. Not only that, actually most of the problems around Limpopo are almost similar. I have done research myself with the regional court president, who was kind enough to provide me with a list of challenges, and which I have also confirmed when I visited certain of those affected magisterial courts. And the Chief Justice wants to know what's the solution. I think this requires political intervention.
Political or executive? Political or executive?
Let's call it executive to be precise, and I stand corrected. The Department of Public Works, which is well known to be an executing agent or department of all state departments, is required to make sure that there are maintenance contracts in place. Because the problems are the same: shortage of water, especially in the area of in Toyando area. And it's not even a question of whether ESCOM has cut lights or is load shedding, but the municipalities in some cases simply don't pay the required bills, and the costs are affected. Another thing, another challenge that I've picked up, Chief Justice and the honorable commissioners, is that there's a competition rather between the Department of Public Works, that is the national one, vis-a-vis the Department of Justice, in the sense that one would pass the buck and say, but it is that building, for example, the Polokwane building, which was gutted by fire some 5-6 years ago.
The magistrate court.
That is indeed, Chief Justice.
Yes.
There has been a tug of war between the two departments, as if there's no cooperative governance established under Section 1441 of the Constitution. That department, there must be interdepartmental cooperation, but that hardly occurs. Like in this instance that I've just mentioned, there has been a challenge as to which department is responsible for the maintenance or refurbishment of that court.
Yeah. All right. Now, just to step out of it, on the occasion of the official opening of the Limpopo High Court,
yes,
the JP, Minister Masuta, and I, the regional head, and I stand to be corrected, but I think even the public works officials had an urgent meeting there. And all those challenges were identified, including the Limpopo Magistrates Court.
yes,
And we were led to believe that, it's just a matter of a year or two. Everything would be resolved, including the water that tends to flow quite ferociously on the basement of the newly built High Court itself. So are you saying that that hasn't been resolved yet?
No, not absolutely.
The infrastructural challenges that had been there throughout the province, as well as the High Court itself?
No, that has not been done, Chief Justice. And I have before me, for example, a report dating as early as 2019 in June,
yes,
which I have sourced from the office of the regional court president.
Okay.
And I quoted.
Okay. No, I think it is okay on infrastructure.
Yeah.
Apart from infrastructural challenges, what other solutions have you identified as those that you could share with the JP to strengthen the leadership of the judiciary in the province? Just very briefly.
Yes. One other area of concern that was raised by some of the regional court magistrates was that they've got a problem with lack of office space.
Sure. Yeah.
And secondly, the legal aid practitioners are few and operate in, for example, in Zanin, regional court, we only have 2 legal practitioners there, drawn from the legal aid South Africa. And there's a lot of work, according to the report that I see here, which now the 2 cannot cope. And the issue of the fastnet internet, for example, so as to enable virtual appearance is also a matter of concern.
Yes. Now, but what strengths are you bringing in very quickly? As an individual, what is it you know? What skills, what capabilities have you developed that you are going to inject into the leadership of the judiciary in the province? Just very briefly, additional to what you have already told us.
Chief Justice, it is very important to keep a rapport from time to time with the magistracy, so that one is able to diagnose what their problems are. Not only in relation to failing infrastructure, but also in relation of other administrative matters. One other quick one that I mention quickly is that the acting magistrates, for example, who have been appointed are allegedly lacking in terms of experience and training. Therefore, it would be adequate for one to introduce the same training course that is offered to the regional court magistrates to be extended to the acting magistrates. And SAJAY would be an appropriate body to educate.
Well, for what it is worth, you're going to have a big fight with the Deputy Minister of Justice and Constitutional Development. He serves in the SAJAY Council and he has views on extending training to active magistrates. But that's an argument that you can have with him on the side. Let me hand over to Judge President Makobase, and then the more that you need to say will come out as commissioners I put questions to you. But before I do, may I have the names of my colleagues who want to put questions to Judge Patudi, please?
Makwanisha,
Lamola,
Muimang,
Tepe.
Matolo Lepu,
Mpofu,
Schlemmer.
Malema.
Jenny Kane,
Arnold,
JP Mlambo,
Aba,
All right.
Sigogo,
Thank you very much. JP, over to you.
Sigogo, CJ.
Thank you, Chief Justice. I don't have any question for the candidate. Thank you.
Thank you very much, JP. Mr. Singh?
Thank you, CJ. Good afternoon, Judge Patudi.
Good afternoon, Commissioner Singh.
So whenever traditional leaders litigate against the provincial government, they always cite the Premier and the MEC, obviously because the assignment of the traditional leadership legislation is assigned to the MEC Coxstar.
Yes.
Recently, we were at the High Court, and luckily for us, the JP dealt with the matter, where the litigants asked for the Premier to be held in contempt because they hadn't complied with a court order where they were given 10 days to recognize a senior traditional leader. If you are appointed to this post, how would you ensure that we don't have unreasonable court orders like the kind I'm explaining about? Thank you.
Well, the question of non-compliance with court orders is a matter of grave concern to the judiciary and under general. The quickest way to do it is to undertake what I would call a mediation process. You call the parties in default and sensitize the official whether about the non-compliance with the court order and show the consequences that might ensue for want of compliance. Unlike to flex one's muscle and immediately issue out a warrant or authorize a warrant for the arrest of the Premier or MEC. But if it comes to a push, after being sensitized in that way and nothing happens to us complying with the court order, then there's no alternative because the law says judges are there to uphold the rule of law without fear, favor, or prejudice.
Thank you. Just a quick follow-up, CJ. No, I understand that, and thank you for that answer, Judge Patudi. But I'm talking about cases where the court order issued by the judges themselves is unreasonable. As you would know, it is highly unlikely to recognize a senior traditional leader within 10 days, given the processes that must follow before recognition.
What is the question?
So the question is, how would you, if appointed to the position, ensure that the court orders made by some of the judges are not unreasonable to the extent of the one I'm talking about?
Well, as I've indicated, unless I don't understand your question, I would say upon reading a judgment, of which now it has a court order, and there is a period within which there has to be compliance, you need to give grace. For example, call upon the defaulting party that you are required to comply within a certain period of time. And if you do not, then it means you are visibly in contempt of court.
Thank you, CJ.
Just a follow-up, CJ. I know I'm on the list.
Thank you, Honorable Malema. Go ahead.
Judge, is it possible for you to tell another judge not to issue unreasonable judgment?
No, that is not possible.
It's not possible.
Actually, you would be trying to review or appeal judgment of a colleague, which is not acceptable.
So it is given that from time to time there may be unreasonable judgment or reasonable judgment,
yes,
which you have no control over as a DJP.
Indeed, yes.
Thank you.
And the avenue is clear for one to approach the higher courts for relief.
Thank you,
Honorable
CJ.
Moganishe. Thank you, sir. Thank you.
Thank you very much, CJ. Good afternoon, Judge Patudi.
Good afternoon, Commissioner.
I would just like to raise a few issues which were raised as comments against you.
Yes.
And give you an opportunity to respond to those comments. One, it is said that you are very disrespectful to practitioners who appear before you. You presided on a matter involving your wife, and that judgment was overturned. And if you can just update us, how far is the dispute between yourself and the Society of Advocates regarding the property deal? If you can just comment on those issues.
Thank you, Commissioner. I had expected this question to arise, and I've prepared a 37-pager document. I'm not sure whether the Honorable Commissioner has received that document. To answer your question pertinently, there is no dispute between myself as a judge and Polokwane Bar Association. It is only a comment raised on behalf of that association by the author of that letter of objection. The property was indeed let out to Polokwane Society of Advocates at the instance of its chairperson. I'm not sure whether you want me to provide the name because it's there in the documents, but he approached me on the day on which the Polokwane court was open, and he said to me, Judge, we have got a serious shortage of office space for the newly admitted advocates, or rather pupils who had just passed pupil age. Then, after the official ceremony, the opening up of the court, we drove together to my former office where I practice as an attorney. He inspected the premises and immediately asked that a lease be drawn rather, and agreement be entered into between Polokwane Society of Advocates and MG Patudi Incorporated, which is the owners of the property, not a legal practice or legal firm rather. From there, a lease was concluded for a period which had a period of 5 years duration. And in the second or so years, notice was given that they are pulling out because they can't pay rent to MG Patudi Incorporated, which is an independent juristic person. And from there, later I was notified that the company, that is the incorporated company, may sell that property to any other interested buyer, willing buyer or seller, between willing buyer and willing seller, I want to say. Then from there, the property indeed was purchased, and the new owners wanted to continue to receive their rental. That is where the dispute began. And that company, the new owners, apparently issued summons against Polokwane Society of Advocates based on the lease agreement. Now, for that reason, I am personally not having any dispute with other members of the bar of Polokwane. I know I've been interacting with them throughout from 2016 upon my appointment as a judge to date. And if you look at the document, Commissioner, you'll note that this is a repeat of old and stale allegations, amongst others that I've presided over a case in which my wife was a party. That is not correct. I think they've dealt with that issue on page 1 Page 5. Okay, maybe let me put it paragraph 17. I know I've paginated my documents. And I've dealt with that matter in the sense that the applicant in the matter consent was one in which Silver Edge Training was the applicant, and the MEC for Education, Limpopo, was the respondent. The matter revolved around a review of a tender which was disputed by Silver Edge, pursuant to a certain report emanating from, and I know I might bend my fingers here, from a Minister of Finance at the time, because there was a lot of corruption in this tender. Mepatudi was not a member of this close corporation, nor holds any interest therein. Additionally, she was not party to the litigation as alleged at all. And I've actually provided the honorable commissioners with a CIPRO, that is Certificate of Intellectual Properties, the one issued by the Register of Companies. And to my recollection for that matter, Commissioner, even the senior counsel who appeared in that matter, I don't want to mention his name, for the MEC, did not even bring a recusal application if he thought that I was conflicted. If I was, I would have simply recused myself. I know what conflict of interest is. So therefore, I want to submit that allegation that my wife participated has no basis. Actually, that report issued by the Treasury, if the Honorable Commissioner has gone through it, no mention of the names of the companies that participated in that tender appear at page 5 of that report. Nowhere is Mrs. Patudi's name rather mentioned, but instead, the affected party there was Silver Edge, and Mapatudi is not or was never been a member or holding any interest in that close cooperation business. So therefore, this allegation has no merit, and the evidence is there.
CJ, but please just follow up on Judge Patudi's, just a follow up.
Yes, ma'am.
Let me first find out if Honorable Magwanisha is finished. Honorable Magwanisha, are you done?
The last part, CJ, was not answered. The last part is to the effect that they say that the judge is disrespectful to practitioners that appear before him. Judge Patudi, it's important for us to ask you these questions. We have read the documents, but there are many people who are listening or who are watching these proceedings who have no access to the documents that we have.
I agree.
So
yes.
it's important that we do ask these questions.
Yeah. Let me respond. I beg my apology for having skipped it. It was not deliberate. I deny that I'm in any way disrespectful to any of legal practitioners within that organization. And remember that, as I said, Polokwane, if the members of Polokwane, if they had any gripe against me, I am sure by now, on the 5th year as a judge, the SGA would have received so many complaints of unethical, inappropriate, dishonorable, disrespectful, complaints within the meaning of Section 14 of the Judicial Service Commissions Act. So far, nothing has been reported. I therefore, in a nutshell, want to make it very clear that I work very well with the rest of the members of Polokwane Society of Advocates. And remember, that is it's not the only bar there. We have another bar called the National Bar Council of South Africa, which has a lot of membership of advocates who never even raised a complaint alleged by the author of this damning objection. Secondly, we have Polokwane Attorneys Association. Many attorneys practicing in Polokwane. Not even one had ever raised a voice. in which my conduct was deprecated, as alleged or at all. Thirdly, we have another splinter group of some of the members, previous members of the Polokwane Bar, who had formed a new bar called the G20 Group. Equally so, none of them had raised any issue. So I therefore, in a nutshell, Commissioner, say that I've had a cordial relationship with the rest of the members of Polokwane Society of Advocates, except for this.
Thank you, CJ. Thank you, Judge Patudi.
Thank you, Honorable Magwanishe. Commissioner
Sorry,
Matapepu,
There's
Commissioner-
something there's something that arises out of that. It's just a short question. May I take it up at this point, please? Jenny came here.
Can you come after the follow-up question by Commissioner Matelo?
And Cyril Taba for
Certainly.
the follow-up, Chief Justice. I will then forego my slot.
Okay, thank you, CJ.
These guys, President Ramaphosa, these guys. Yep.
Commissioner Matelo Lepu, I think one of the commissioners was busy with something else.
Oh, okay. Thank you, CJ, and good afternoon, Judge. I just want clarity. The issue of MJ Patudi Incorporated, knowing according to our rules, and Incorporated is owned by attorneys.
Okay, no, not necessarily. I'll explain as follows. May I reply?
Yeah, that's why I wanted.
Yes, I would like to clarify that.
Yeah.
These incorporated structures are incorporated in terms of the Companies Act, and this one in particular as a personal liability company. It's just like a private company. Now, it doesn't always follow or necessarily follow that once you incorporate it, therefore it means you should be in legal practice. Incorporated companies are business entities incorporated under the company laws of the Republic. And it all depends the purpose for which it has been floated. The incorporated company may trade in tendering, road construction, or all other business opportunities that are there in the commercial, in normal commercial course. Then, for even medical doctors, some had registered incorporated companies, but they're not necessarily attorneys. You have also pharmaceutical companies, the owners thereof, they register an incorporated company as a personal liability company, which exists separately from its members. So in my case, I was a single practitioner. The company was registered as early as the year 2000. In 2005, using the name Incorporated, MG Patudi Incorporated, then I managed to secure money to buy the property, not to buy the practice, because I was issued with a fidelity. MG Patudi, in my personal capacity, was issued with a fidelity fund certificate, not in the name of MG, because MG Patudi Incorporated is not an attorney to all intents and purposes. So therefore, there is this, like the writer of this objection, with respect, did not actually misconstrued how these entities operate. The moment I ceased to practice as an attorney, then I informed the Law Society that MG Patudi Incorporated, practice number 19190, I've ceased to actively practice and I am now going to join the judiciary. But the incorporated part of it, which is the owner of the building, remains intact. In other words, from now, anybody who's a shareholder in that or a director may enter into construction or mining or any other business entity.
Sorry, Chief Justice. I just want, my problem is when you deal with such things, when you are an attorney and seasoned to be an attorney, it's actually clouds issues. When you registered this Inc. before, who were the shareholders and who were the directors before leaving?
I was alone, single practitioner.
Then you dissolved, you deregistered the Inc.
No. I haven't deregistered it. I've relinquished my shares in the ownership of the building itself, of the company itself, with the result that anybody in whose favor those shares were transferred can now step into my shoes, but not necessarily as an attorney, because MG, that is myself personally, had ceased to practice as an attorney. And my name, I'm sure, wherever it is, it has been and put on the list of non-practicing attorneys.
Okay, I don't want to enter into a dialogue, but
No, I do want to have a follow-up on that issue. Chief Justice.
She's still on the floor.
Oh.
Wait a minute, Commissioner Matolo, are you done with your follow? With your floor?
Not because I still have another opportunity. So let me give Commissioner Madonsela to follow up.
No, it's not even him. It's first Commissioner Kane. I just forgot who comes after Commissioner Kane.
It's Taba, who then forgo his slot here.
Yes. It's and then Commissioner Madonsela thereafter. Okay, it's all follow up. Yeah.
Yes.
Okay. Yes,
Thank you,
Advocate Kane. Advocate
Thank
Kane,
you.
is your turn.
Is that?
Thank you, CJ. Good afternoon, Judge. My follow-up question on this, you refer to William Macari ST complaint as being a single advocate, but he writes very squarely as the chairperson of the Polokwane Society of Advocates. And so your dismissal of the matter as if it's not on behalf of a broad body of advocates I'm putting to you is perhaps a little misleading. You perhaps need to explain or be fair that this is a complaint directed relating to, from the chairperson of the Society of Advocates that practices in that division.
So I missed some of your words, and if
I am sorry.
you'll pardon me if I don't correctly answer your questions. But the little bit I got was this: whether is this complaint not raised by Polokwane Society of Advocates? Yes, I've indicated that the chairman of that association is the one who wrote on behalf of the Polokwane. But the issues raised therein, which do not even rank within the definition of a complaint in the judicial sense, are, in my view, issues that emanated from him on behalf when he sought to let the property for purpose of use by the advocates who are practicing in that within that bar association. So I still want to. My thinking is that this is not a judicial complaint. If it were, I'm sure the Judicial Service Commission would have received a complaint within the meaning of Section 14.
CJ.
No, let me just try and see if we can narrow the issues here.
Yes.
Judge, who was in charge of this part to the incorporated ever since you became a judge?
The property, the shares, let me say, of MG Party Incorporated were transferred into the name of May Patud.
Now, was May Patud the warm body behind Patud Incorporated? Was he the one running this property that belonged to MG Patudi Incorporated?
Yes, after my departure from as a legal practitioner. So in other words,
Yes, but you are the one who drove the advocate to the building.
yes, I facilitated. If you look at my response, Chief Justice, I said I facilitated.
No. I'm just trying to narrow the point.
Oh, yes.
So you took the advocate to the building.
Yes.
And I take it, showed him around.
Say it again, Chief Justice.
And showed him around.
Oh, yes. He inspected the building, yes.
And then did you conclude the agreement with him, or did you leave it to your wife to then conclude the agreement?
I left it to Mepatudi, who signed the lease agreement, because I was a mere facilitator. And I think on page of this response, my response.
So you, as a judge, you were facilitating this contract?
I facilitated the use of the building. The lease was signed by Mrs. Patudi.
Okay, all right.
Yes.
No, thank you. Honorable Kaba?
Thank you very much, CJ. I would have wanted to follow up on the question that the CJ has asked.
Yes.
Whether the shares that were transferred that are now registered in the name of Mayor Patudi,
yes,
constitute a declarable interest in terms of the disclosure of interest policy of judges.
Yes.
And if yes, were these interest or this interest declared accordingly? Then my second question, Chief Justice, because it's unrelated to this one, it's a follow-up on Commissioner Makonisha's question. To the extent that the judgment in question was overturned, was this allegation of conflict of interest one of the issues or matters raised in the review or appeal application? Thank you so much.
Okay.
Thank you, Chief Justice.
All right. Commissioner Kaba, the position is as follows. In relation to your first question, if you have regard to paragraph 5, starting from paragraph 7. I'm not sure whether you have a copy, but I'll read it for into the record for your purpose. And it reads as follows for those who found it. Significantly, this transaction was still was until the property was sold to Tshwaranang and registered its name as new owners on 26 November 2018, disclosed to the registrar of judges' registrable interest as a source of other non-judicial income that accrued to MG Patudi Incorporated. And I've repeated this on paragraph 9, same page, that this transaction was, as already indicated in paragraph 7, disclosed to the registrar of the judge's registrable interest at the time. There was nothing, therefore, unlawful in that transaction, as the writer had alleged there. That is the first part of your question. The second one is whether, as a result of this alleged participation of Mapatudi in this review, clearly, as I already indicated, the writer of the objection had misconstrued the whole thing, in that Mapatudi never participated in the tender, in the dispute, and secondly, she holds no interest in the word. But what has happened is this: when the matter was before me, argued between the MEC, who was the respondent, and Silver Edge, the document which I have referred to as the report on the verification of compliance with Treasury, norms and standards, appointment of 9 manufacturers. I'm not sure whether you've seen that, Commissioner Trevor. It gives a detailed background of what led Silver Edge to approach the court by way of review. Because according to him in his papers, the officials were handling that tender were somewhat, according to him, corrupt or were corrupted. And the report is quite detailed. If you have a look towards the end.
I think, Judge, you have answered me that this matter in particular, this allegation of conflict of interest, never featured before you, and it never featured even on appeal or review.
That's it.
Thank you
And
so much.
if I may add quickly, if this report, this very report, was made available before the court, either by the applicant or the respondent, surely that SCA decision would have turned otherwise, because it was not made available.
CJ.
If it's a follow-up, Commissioner.
Yes, it's a
Malema,
follow-up
sorry.
on that incorporate thing.
Yes, is that before? Let's come with Commissioner Madonsela, and then you come.
Okay.
Thank you.
Thank you, Chief Justice. I'm also dealing with this incorporated thing. If a company with limited liability owns a property in which you are a shareholder and a director, sole shareholder and director. Judge Solomon, good afternoon, Judge.
That is right.
How do you relinquish ownership of the property?
By transfer and registration in the office of the registrar.
Transfer of what?
Of the property itself, not the shares.
So
in the incorporated company.
So you transfer property to who?
To the new owners. In this case, is Soranang.
So you transfer the property from the incorporated company.
Ownership of the property.
But the company
owns the shares and the building itself.
You know, how do you then transfer ownership?
Of the property or of the shares?
Of the property.
No, as I say, upon deed of sale of an immovable property being concluded.
Between who and who?
Between the owner, the registered owner in the deeds office. Then it was myself in my personal capacity, not as a judge. Because when I got this property in 2005, I was not yet a judge. So the property was registered as under MG Patudi Incorporated, of which I was the sole owner.
So you're not owning the property personally. You're owning.
No, yes, which is why I was able to. The property was sold as an incorporated company.
No. You said you owned the property in your personal name. Then you turned around and said you owned it in the company's name. Which is which?
I'll repeat. Unless I miss something. But I say in the year 2000, a company, MG Patudi, was incorporated. And whilst it was in business or trading, in 2005, in the same name of MG Patudi Incorporated, then purchased the building and continued to trade as a legal practice, whilst I'm an attorney. And when I relinquished my status as an attorney, the property still retained its ownership of incorporated. That's how it is. Now, if somebody were to trade, as I say, outside legal practice, let's say before it was acquired. Let me give you an example that after having transferred the shares in the incorporated company into Mapatu, then she would have easily, for example, traded in any other field except legal practice because she was not an attorney. That's how it is. And then, upon sale of that property to Tshwarana, cancellation, those who understand conveyancing would say that there is transfer and registration that has to take place in the deeds office. And that's what took place. No any person could have effected transfer because from the word go, the property was under MG Patu Incorporated.
I'll go back to the question I asked. So how then did you relinquish ownership of the property when the property was held in the name of the incorporated company?
We don't relinquish ownership. You transfer ownership by registration in the deeds office.
I'm using your words. You said relinquished.
No, I meant the shares,
Yeah, relinquish the shares.
not the property. Mr. Madonzela?
Chief Justice, I'm constrained because my learned friend, Commissioner
No, come on.
Commissioner Mpofu is offering questions loudly behind me, and I don't think it's proper.
Offering questions?
I'm leaving it at this because I wanted clarification for myself.
Chief Justice, I apologize. I didn't even see that my mic was on, and I realized now. Sorry, I'm sorry, Chief Justice.
It's not a problem about the mic, about you offering questions, answers from the side. That's a problem. Let me leave it at that, Chief Justice. I think we have traversed the matter for fairly too long.
Thank you. Thank you very much, Jesse. Honorable Malema?
Thank you, CJ. I'm going to try and engage with this thing from a layman's perspective so that we avoid this lawyer's approach on this thing. So now, in 2000, you established a company called, you're calling it Incorporate.
MG Patu Incorporated, yes.
It's a company.
Yes, it's a private company.
Registered with CIPRO.
Yeah. In the deeds office.
No, not the house. Let's leave the house.
Yes.
You register a company with CIPRO.
That's correct, yes.
And then it's called MJ Patu Incorporated.
That's correct, yeah.
You are a director.
Yes.
And then you are 100% shareholder of that company.
That is correct.
Alone.
That's correct.
In 2005, this company where you are a director and a 100% shareholder buys a property.
Yes.
While you are still practicing as an attorney.
That's correct, Commissioner.
Then you get appointed as a judge.
Yes.
You then relinquish the legal practicing as an attorney.
That's correct, yes.
But the company continues to live a life of its own.
That's right.
With you as a director and a shareholder.
That's
director, and then when you're now getting out as an attorney.
Yes.
But because the attorney is not the company.
Yes.
The company as a legal persona remains with CIPRO.
That's right.
Registered with CIPRO, but it's called Patu Incorporated.
That's right.
You remain a director.
Yes.
And then you become a judge.
Yes. But before I became a judge.
Yes.
I then relinquished the interest in the company.
I'm still coming there.
I'm
still coming there.
Okay.
So you now become a judge because there are two things here. It's directorship and shares.
Yes.
And we shouldn't have confusion about the two. You can be a director and not be a shareholder.
That's right.
You can be a shareholder and not be a director.
That's correct.
Now, I want to understand, when you become a judge, what is the first thing you release? Is the shares.
Yes.
You then took the shares to Tshwarana.
No. Before that, to Mapatu.
To Mapatu.
Yes.
So you are no longer a shareholder.
That's correct.
So meaning you are no longer the owner of the MJ Patu Incorporated.
That's correct.
You are just a director.
Yes.
Then from there, anything else owned by MJ Patu Incorporated doesn't belong to you. It belongs to the shareholders.
Yes.
And that shareholding has been released to Mapatu.
That's correct.
Then what happens to the directorship?
Well, the directorship like in this case,
Yes.
because the main person, the main role player,
Yes.
had ceased to practice, then it means it died its natural death.
No, the company
What-
still the
what is-
company still registered with CIPRO, and for as long as it's registered with CIPRO, it must have a director.
Actually, yes, the directorship to be, it all depends, this what we call executive director and non-director,
Yes.
executive director. So for purpose of continuity in the transaction towards the conclusion of the sale, it needed somebody to sign conveyancing papers.
Yes.
And I had no choice because
No,
from-
Judge, I'm not interested in the house.
Yes.
I'm interested in the company
Yes.
that holds the house. I
Yes.
want to know, now that the shares are gone to Mepatudi, and then the company is registered with CIPRO, whose name does it appear at CIPRO as a director?
Oh, I see.
Yes, at that point.
At this point, Mapatuji has taken over as director, and I can refer you
So
to.
she has taken over as a director
And the
and
shares
a
as
shareholder.
Yes.
So meaning she has taken over even the liabilities and the properties and all of that of the company.
Yes, Commissioner. And that there's an annex just there on
Yes.
on this response. It's marked as MG2 at. Sorry, it's marked there that the director is now Alice Patuji Matlodi Alice. It's written there. She's taking over the directorship
Yes.
as well as the shareholding.
So this house, the house in question now belongs to Mepatudi as a shareholder and the director of a company that is housing this office,
That's
which
correct.
is in dispute.
Yes, that is correct.
So because you are a community there, this man knows you are practicing in that office.
That's right.
He comes to you and says, no, we want that office where you used to practice.
That's correct.
And out of cordiality and working relations, you say, no, the office is available. I can even take you there.
Yes.
Because you use different languages here, you call it facilitation and all of that. From what I'm listening is, a man approaches you during the opening of the office, you even take a tour at the office there, then you hand him over to the real owners of the office.
Yes,
Then when they are busy renting there, they don't want to pay.
Rental.
And
yes.
when you start fighting for rental, they start writing letters here to complain about you.
That's correct.
Thank you.
That's correct, Commissioner. That's how I also understood it.
Follow up, CJ.
I can,
Follow up, CJ.
yeah, it looks like we have in our Julius Malema as who wants to follow up? It must be too long.
Sigogo.
Who wants to follow up?
Sigogo.
Okay, please follow up, sir.
Thank you, CJ. Good afternoon, Judge.
Good afternoon, Commissioners Gogo.
The issues which I will need to be clarified.
Yes.
Yeah. About this incorporation. When we incorporate a company, a personal liability company, we do memorandum of incorporation.
Yes.
I think back then in 2000, it was articles of association.
Yes.
In the memorandum of incorporation, we state what this company is going to do.
Yes, the main business. Yeah.
The main business of
That's
the
right,
company.
yes.
And what was the main business of this company when you incorporated it?
No, it was registered as general trading or trading in general matters.
And it also ran a law firm as a general trading.
No. When I became an attorney, I traded in that building as attorney MG Party Incorporated. Now, the main business upon registration of this company was registered as general trading, but I only used that property and the business name MG Patudi Incorporated to practice as an attorney. Now, when I ceased to practice as an attorney, the building remained registered and incorporated with nobody inside.
I'm not talking about a building as yet, and I'm not sure if I'll talk about the building. I'm talking about MG Patudi Incorporated. What is the memorandum of incorporation of MG Patudi Incorporation?
With respect, I thought I've answered that the company was registered as a general trading company. That was what was included in its memorandum and articles of association.
Okay, so then I think maybe if the Law Society had known that that is the memorandum of incorporation or articles of association, it will not have allowed you to operate.
Unfortunately, they did because I informed them.
Okay.
Yes, there was nothing illicit about this. Absolutely not.
Yes.
And so far, even when I returned my Section 78 audit certificates, I did so attaching the letterheads and everything to show that I'm trading as MG Patudi Incorporated.
Okay. So let's come to shares.
Yes.
In terms of the Attorneys Act, under which you operated, the people who could hold shares in an incorporated firm of lawyers,
yes,
are only lawyers and no one else.
If you're practicing as an attorney, under Fidelity Fund certificate issued under Section 78.
No. Let's not deal with the Fidelity Fund certificate. Let's deal with the incorporated, because I think it will be very clear. Personal liability companies in the Companies Act are reserved for professionals, are reserved for medical practitioners, are reserved for accountants, are reserved for lawyers. And they operate under incorporation. And it is personal liability because the liability, I want to deal with this, the liability of the company are not separated from the liability of the directors.
Yes, I agree.
So
what's the problem, Mr. Sgogo?
So there is no two personalities like in other companies, because if that is allowed, members of public will be left in the cold, will not be protected by the legal practice Fidelity Fund. Back then it was the Attorneys Fidelity Fund. If they were separated, they were one thing. That's why only lawyers in that incorporated will hold shares and will hold directorship. No one else.
In which company are you referring? Are you still talking about MG Patudi Incorporated?
Yes.
Okay.
If it was running a law business, unless if it was running something else.
I would like to say MG Patudi was trading, Incorporated was trading as attorneys up to June 2016. But between this period of April, when I went for interviews and having received a recommendation for appointment, Then I started to put systems in place in order to, I would call it in inverted commas, to liquidate the business. And one of the quickest things that I thought of, because there were things like furniture inside and many other things, including the property itself. That is when I informed the Law Society that I am no longer practicing for purpose of, say, expecting a fidelity fund certificate from me anymore. And then the building, the shares and directorship was then, prior to that, transferred to Mapatu. And that was effected according to the CIPRO documents that I have on the 7th of April in 2016. It appears in my response.
This complicates issues. Because if the shares and the directorship were transferred on the date you just mentioned now, you signed the documents for the sale of the building in 2018.
Yes, that is correct. But in my capacity, not as a judge, but as the registered owners initially recognized by the deeds office in 2005. There was no any other person who could sign the transfer documents.
No, if you transfer your shareholding and in a company, and when that company holds properties, the new shareholder should sign, not you.
No. That is not the position. That is not the position, Mr. Skoko. Ownership of the building, he who or she whose name is registered in the name, in whose name the building is registered, then in that case, that person must sign in order to effect the necessary transfer. Not of the shares, but of ownership of the business, of the property.
Thank you. I think you have answered, and we should stop somewhere in regard to this interaction.
Yes.
And I will raise some of the concerns during deliberations.
Okay, it's all right.
Thank you.
Well, just to clear this in my mind, didn't you say, in response to Honorable Malema's questions, that the shares and the house were all transferred to Mapatu, with the result that even as you were taking somebody to the house, you are not taking them to your own house, you are taking them to something that belonged to Mapatu. So how can you answer Mr. Sigogo in the manner that you are answering?
I don't. I tried to explain earlier on, but
okay.
Looks like we're hitting a snake.
We don't get it. Yeah, we don't get it. Okay. Honorable Minister.
Yeah, thank you, CJ. I hope the confusion has been cleared. Because I was also a bit confused with the signing of the deeds of sale to the new owners of the property. But I think Mr. Padudi's last answer clarified that confusion with me.
Yes.
Because I also understood that with this company of a limited liability, but I get your point that it is because you are a transferor, it was an administrative process to transfer the building. So I understand that part. I was a bit confused earlier on.
Thank you.
So my question relates to, I just want us to move from this. I think it is enough now. My question relates to the issue you have raised about the contest between Public Works and the Department of Justice.
Yes.
With regards to maintenance of the buildings. It's not only a Limpopo challenge, it's a countrywide situation. What do you suggest we should do to resolve this difficulty for the infrastructure?
Well, if the minister, if the government has enough fiscus, the immediate thing would just to overall refurbishment of the structures, because as they are, some of them, according to the research that I've done, are in a state of dilapidation, dangerously so, to the extent that it puts the lives of our people in danger. The court, for example, in Toyendo, may collapse at any time because it is old. At some point, it caught fire because the electrical system was in a state of disrepair. The same applies to many other courts in the former homelands. Your Bochum areas, your Nebo, and many other courts, Linyenye, Bulubedu, and so on. What could be done, Honorable Minister, is that they need a total overhaul or refurbishment. And I will cite reasons why I say so. In Zanin, for example, the holding cell has a hole between the property and the main street in town, with the result that the laborers there and those who came to court easily sneak in unwanted material into the holding cells, your knives, your dacha, and related matters.
Yeah, Mr. Padul, those problems we know.
Yes.
And we understand. My question relates to how do we solve them? You know, when you come to us, we say, no, it's a public works issue. As you are aware, it's public works that deals with state infrastructure.
Yes.
And you have said here that there is some form of a contestation, or you're saying there's some form of shifting of goalposts between the two. And when you go to public works, they say maybe they will say justice has not yet reported or is part of justice in terms of their delegated kind of responsibility. So my question relates to how do you think we must be able to solve this problem? So that you know, if I have this problem, I go to this point. No one is going to tell me it belongs to this. Just one tell me that this problem is going to be resolved and this is the procedure. So that is the point I'm asking. How do you help us to help you resolve this challenge that I know is countrywide? Because I've also seen it.
Yes. Well, my view would be this, Mr. Minister, in relation to your question, that the first thing would be to transfer these courts in the names of the Department of Justice, and the department takes over and rather enters into a maintenance agreement with Public Works, which I believe it is an administrative responsibility of maintenance of all state departments' properties. So I think the quickest way would be to enter into, rather transfer these properties and be owned by justice, so that we must know, the public must know that it's either is owned by the Public Works or justice. And if the issues of maintenance arise, say in the future, then we know which department to deal with. Maintenance contract is very important, and transfer, if all possible, of these assets into ownership of justice, that would help resolve the problem. But again, it's a matter of the executive.
Yeah, the difficulty I have with that is that, as you are aware, Public Works is the state agents with regards to these issues. So we have had some kind of, they have delegated some of this. I think, I can't remember the level of maintenance, which is kept for the Department of Justice.
Yes.
But what is emerging from that is that, obviously, when they delegate, remember at Public Works, they already have a dedicated unit and officials. Those officials and dedicated unit remains with Public Works. So justice may also not have that capacity of all the officials that can help across the country. But I think it's something that we can look into and outside this platform for further exploration as to what becomes a real workable solution. But I think I get where you're going to.
Yeah, if I may, if I'm allowed, Chief Justice, just to make a follow-up here as part of the solution, is that, Honorable Minister, is that steps could be taken to ensure that these, in every cluster, there is a head who is put there to make sure that issues of maintenance, refurbishment, and so on will be ensured. But on the other hand, there is this problem that in the provincial administration level, or at that level, we don't have MECs of justice. So therefore, there is a chasm between the administration at national level and the provincial offices in matters of public works administration. So it's one of the things that compounds the problem, because there's no immediate overseeing role by, say, for example, the MEC of justice, who will run around the whole provinces to see the state of repair of these courts.
Yeah, no, thank you, CJ. I think on that one, we are looking into the role of the regional heads of justice to be given more powers to do those kind of things. But I think it's something we'll engage outside the platform. Thank you, CJ and Judge Patuti.
Thank you, Minister. Honorable Mwema.
Thank you, Chief Justice. Good afternoon, Judge Patuti.
Good afternoon, Commissioner.
I think from the elaborative discussion that we have had, I want to ask you two questions.
Yes.
And the first one is whether do you agree that these problems that were raised and your time trying to set out the situation as it is has a potential to create a deficit in the ability of the public that has complained to the JSC about the independence of our courts and the judiciary, because they would have understood that the independence of the judiciary is not about judges per se, but rather the system of justice and the rule of law. And that is will you also agree that if that is the understanding, definitely because of failure to clearly delineate a distinction between the institution and yourself, which has been difficult to explain, has a potential to undermine public trust and confidence in our courts. And do you agree that if the public has confidence in the independence of our courts, all of us are winners? And if there is no independence, all of us will be losers. So don't you think that it might be important for you probably to step aside, allow the process to continue so that you sort out this confusion, because it's also a concern now to the to the structures.
I see.
Thank you.
Okay. Honorable Commissioner, first and foremost, you'll appreciate that if, with respect, you have gone through the response that I've provided in relation to the objection, it all points in one direction. This is a non-judicial matter, this objection. It's non-judicial. It does not blemish in any way my independence or any possible, let me say in particular, my independence as a judge. It's a product of a transaction perhaps that went sour, that affected the a particular, I would say in this case, for lack of better words, the PSA. But for the allegations that are there, for example, I've provided countervailing evidence that would tend to show that this is nothing but personal issues which do not affect PSA as a body, but the person who happens to represent that body in the lease agreement. That's the beginning of the whole problem. But then after I had taken time to explain, indeed, it might sound as a complicated commercial transaction. But to my mind, it shouldn't be allowed to spill into issues of judiciary. If it were a complaint to say that I have done something untoward personally as a judge, then obviously from the moment when the allegation arose, perhaps bordering on unethical behavior, surely the Secretariat of the JSA would have been the first to receive a complaint. But now the complaint, look at this, Honorable Commissioner, the objection comes a second time. In 2019, I had to withdraw because of the same allegations which are repeated here. There's nothing new. I've tried to attach, not tried, I've attached, as you will see, I've referred rather to the initial complaint. I've been open to this commission, played my cards face up. And I've attached this thing. If I was somebody who is playing hide and seek, I wouldn't have produced this document. But then I wanted to show this commission that the timing of this objection is questionable, in the sense that it's a repetition of what was contained in the first, and it came at the 11th hour in circumstances where if I took a risk of coming here unprepared at that 11th hour, I don't know what could have happened to my reputation. Now, I had to back down, like it was suggested by the writer of the initial report, and even this one, that I must withdraw my candidature. And of course, I've gladly done so, because I had to find time in order to collate evidence to negative these allegations. So I would, in answer to your question, say it's unnecessary for one to think of, in the first place, of backing down again. But the best was to come and show you by way of this document, which took me days to collate. Remember, I had to go to Treasury, obtain this document, try to show the writer that I did not sign the lease myself and related matters. And the other allegations made here, which are all negated by documentary proof that I've attached for the benefit of the commissioners. So the judiciary cannot be undermined by allegations of this nature. They're too unnecessary, really, to be honest. I don't want to use other words. It's unnecessary.
The confidence, don't you think that it has a potential to...
The contents?
The public confidence in our courts?
No.
From this process?
No, it won't. As I say, it will only do so if the issues placed or raised border on judicial ethics. So these are not judicial ethics. These are personal issues. The timing of which was always like this. At the 11th hour, then, Commissioner, I'm not sure whether did you have opportunity to go through other comments made by other credible law bodies.
Yes.
Six out of them were all in favor of my recommendation by this commission. Of course, it's just a recommendation, I know, but then just one dissenting voice out of 6. What is that? And it's a repetition.
Thank you, Justice. Thank you, Chief Justice.
Thank you, Honorable Moimang. Commissioner Tsepe.
Thank you, Chief Justice. Good evening, Judge.
Good evening, Commissioner.
Judge, I want to step out of the discussion on the property. There's one clarification I need though, but we'll get to that. Yes. When you were talking earlier about the challenges facing the division, I think it was after the CJ's questions, you spoke mainly about infrastructural challenges.
Yes.
I want us to talk about challenges, or if they are, relating to the running of the court, of the division itself. And I wanted to find out from you if there are any challenges that face your division that might hinder timeous delivery of judgments. And if there are, what interventions would you propose to capacitate the judges to meet the expectation in this regard? Yeah.
All right. Let me approach your question from this perspective. First, that court in Limpopo, both the Polokwane High Court and the Thohoyandou local division of the High Court are, to my mind, running quite efficiently. But the challenge is this. In Polokwane, for example, we have a great deal shortage of judges, permanent judges. This has been the position since 2016, when the court was established. I know the JP has been engaging with the various ministers in the Department of Justice to try to strengthen the division by introducing more and more judges. But it looks like, as I understand, that the money is gone. The fiscal has been depleted, the fiscals. And we're not being promised as to when sooner will more judges be available. Now that put a spanner on case flow management, as well as the judges being overworked, because you're required to sit almost every day in court. At times when you're assigned to do motion courts and then it collapses, then you take over criminal cases. There's no what you call reading days in Polokwane. Now, we work every day and twice on Sunday. At times we're unable to go to church because spending 2-3 hours in church, when you come back, the day is gone. It's Monday already, and that affects the production of quality judgments as speedily as it is required of judges to produce judgments. Now, these things impact negatively on case flow management. The other issue is the dysfunctionality of the recording machines in our courts. I'll speak on behalf not only of the High Court, but I heard even in some district magistrates court there are problems there. Most of the time, those machines are not working, and there are no backup systems, with the result that in the middle of proceedings, in the afternoon, then the whole system collapses. And that makes our work difficult. What are the solutions? The solutions, again, is a question of maintenance agreement between the department and Public Works. That's my submission.
Thank you. Judge, I just wanted to check something in relation to the memo. I think that you wrote in response to the PSA's
Yes.
Objection. I want to categorize it as that because it's not a complaint to the JSC in the normal course. This is just an objection to your application.
Yes.
I wanted to understand why somewhere you say that he wrote again to me, meaning he wrote a letter to you in one of the in the memo. I wanted to understand that if MEPADUDI.
Which paragraph would that
I'm
be?
trying to get the. 13. Pursuant to the above stated notice.
Which paragraph?
13, paragraph 13. That,
Oh, okay.
I think it's page 4 of paginated page 4. Mkari SC again wrote to me
Yes.
on 14 June 2018.
Yes.
So my question is why you were facilitating the process of viewing the lease property with Mr. Mukari at the time of entering into the lease agreement. I understood you to be saying that's the end of your participation in this transaction because the transaction would have been between PSA and MG Patudi Incorporated, represented by its director and shareholder, Mepatudi. So why would Mr. Mkari then write to you in 2018 regarding disputes relating to the lease agreement?
I see.
When you are no longer, and as you say, he wrote to you again, meaning at some point prior to 2018, he would have written another letter to you regarding the continuation of or termination of the lease.
Okay.
And this raises a concern for me that you were still participating in one way or the other in this. So if you could clarify that for me. I heard the minister saying your answer about you signing the transfer clarified it for him. I just want to say I didn't get the clarity. And if you could, I know you've traversed this matter a number of times, but I don't want to go into the deliberations with question marks in my mind. And if there is clarity that I get from you, I would much rather I get that directly from you. You said that the property is in the name of MG Padudi. When in 2016, when you left, you would have resigned as a director, and Mepadudi would have been the sole director because the certificate shows Mepadudi as the only director, the only active director. So it shows that you're no longer the director in terms of the annexure on here. What I wanted to find out is once you have sold the shares, so the shareholder and the director would be Mepadudi. So the shareholder, the director would in-law or the board, which is represented by the director, are the only people who can represent the entity. So that would be Mepadudi because the property is in the name of the Inc. So how would you then, having transferred the shares and the shareholding of the Inc. to Mepatudi still have the authority to sign transferring papers, because that act can only be done by the person who is responsible for the company. And that person would be Mepatudi, not you. That's my understanding of how companies are run.
I see. Okay, let me start with you, Commissioner Sepe. Let me start first with the letters that you've referred to. It was an interval of just 2 days in between. The one was issued on the 14th of June 2018, in which the author refers to paragraph 1 thereof, as per our telephonic discussion previously. So there has been an ongoing discussion in terms of which the society had conveyed their predicament in terms of continuing to pay the lease. Now, if you turn to page 3, that's the reason why that letter was written, that the situation is beyond our control, and we therefore cancel the agreement as stated above. I was informed. Now, you want to know why was the letter directed to me? I go back to say that we had a good working relationship with Advocate Mokare, so he knew me, but I facilitated the transaction. That does not derogate from the fact that initially when the lease was signed, I facilitated the lease agreement. Similarly, the page before is a letter dated 16 May 2018. Paragraph 2 thereof says the Bar Council of Polokwane Society has resolved not to exercise its option to purchase the property at any stage. You are therefore advised to proceed to sell the property to any willing buyer. So he gave an advice in writing so that I conveyed to the person who's in charge of that property.
Chief Justice, I think that's fine. I just think my challenge still remains, Judge, in that if the person responsible for the property is Mepatudi, whose details would have been available to the PSA, they would have written directly to Mepatudi, or you would have responded to the PSA and said, sorry, you are addressing your letter to the wrong person. The person responsible for this matter is Mepatudi. In future, in order to not create any difficulties, could you please direct all your correspondence to her?
Yeah, okay. Do you still anticipate a reply? Okay, thank you.
Commissioner Matelo Lepu.
Thank you, Chief Justice. Judge, I've already treated you. You know, one of the things that worried me when you spoke about the magistrates, that they need training in, you know, and I'm a bit concerned in the sense that it seems the problems are insurmountable.
The problems are?
The problems are insurmountable.
Oh.
In the sense that there's infrastructure, then here there's human capital of magistrates not being trained. So for me, I see this gloomy picture about the courts, the magistrates and in Limpopo. How are we going to get out of that conundrum?
Yes. There is, for now, a program meant to train regional court magistrates. But then a similar program for training is not being accorded to either acting magistrates or newly appointed magistrates. What are the consequences? The report I have here after done my research was that it results in backlog because the learned magistrates who've just recently been appointed are lacking in experience and for example, in producing speedily judgments, and therefore that puts it tends to paralyze the whole system. The solution is that one that, yes, perhaps one has to weave a plan in terms of which these magistrates, newly appointed and the acting ones, could be exposed from time to time to seminars, training, and any other way, method, or manner in which they could be empowered.
Well, Judge Paturi, for what it is worth, President Maya and I serve in the Council of Sajay. We train anything between 200 and 300 newly appointed magistrates almost every year.
Yes.
And they participate in the planning and development of their own training programs. So there is a system in place. You may not be aware.
Oh yes. Perhaps I meant for the system for the acting magistrates, not regional magistrates.
Just a follow-up. I'm just worried about the women issue. Out of the regional magistrates now, how many are women who are actually senior, who can actually be asked to act? Because I don't think everybody is acting.
To act at magistrates level.
Yeah.
No, there are quite a number that I know of, and who have amassed massive experience running the regional courts, the majority in Limpopo. Having graduated from the ranks of prosecutors, additional magistrates, and for others, of course, becoming chief magistrates and regional court magistrates. So the senior ones, of course, if the resources are available, they can still conduct their own training.
Okay, thank you, CJ, and thank you, Judge.
Thank you, Commissioner Madelo Lepu. Advocate Mbofu, SC.
Thank you, CJ. Okay, I thought of foregoing my slot because I was covered in my original question, but there's just something I want to clarify. I'm sorry. Good evening, Judge Paturi.
Good evening,
Yes.
Commissioner.
Thank you very much. Yeah, no, I'm sorry, I'll go back to this issue that I didn't want to go back to, but from a different angle.
Yes.
So the minister and I are both former attorneys, so we were schooling each other here. At least we, in this thing of the intersection between the Companies and the Attorneys Act and property law and so on, which is quite complicated. So, and I wanted to apologize again to Commissioner Madonsela. We were whispering aloud, and you were, I know it can be irritating when behind you don't know what's happening. But at least it contributed in clarifying the minister. So that's my mitigation.
Unfortunately, it didn't. It compounded the problem.
Okay.
For me.
Okay. Yeah. I'm sorry. So the issue really that I want to talk about is this. You are here for a leadership position as Deputy Judge President of the province.
That is
right?
correct. Yes.
And Commissioner Tepe, I think, also touched on this. There is no complaint before this commission about you as a judge.
Yes.
Correct?
That is correct.
In other words, there's no complaint that says because of this or whatever property thing, your position as a judge should be questioned, or any of the three contestants that are here.
Yes.
And you are here to apply for a position as to whether you should be the Deputy Judge President while you are already a judge. All three of you are judges there.
Yes.
And there's no question about that. Yeah. So when we consider this whole thing, it must be in relation to the simple question of whether you should be the DJP or it should be the one or it should be the other one.
Yes.
Okay. Yeah. So I think that that's very important for perspective, because I think there seems to be, don't want to call it confusion. That was the sense I was getting, that this was now about a complaint, but I think Commissioner Tsepe clarified that.
Yes.
So now let's come then to the core issue that brings you here, which is the DJB position.
Yes.
You, having acted as a DJP in the position that you've applied for, can you just share with us? Someone else asked you earlier what were the challenges and so on, but what I really want to know is having acted in the position, and I'm not sure if the other two people did. Do you know if they also acted?
Oh, to my knowledge, not.
They did. Okay. So
it's only not between the two other contestants.
Yes.
Yeah.
Okay. So then, what advantages do you have having acted there, of having observed what happens in that division? Can you bring, if you are appointed, can you bring to the fore? In other words, what slight advantage would you have emanating specifically from the fact that you have acted there and you know what it is that you are applying for?
Thank you, Commissioner Mpofu. Yes, firstly, let me confirm that I've had privilege to act there as a deputy judge president for 2 terms in succession. And one of my roles was to deputize the judge president on some of the administrative matters, quasi-judicial as well as judicial in character. And talking about the court operation itself, in that division, when you're a DJP or acting as the case may be, on every Monday, you attend to a roll call of civil court actions or matters, which by and large would be between 70 and 80 per day on that particular Monday, most of which would be RAF matters. Of course, here and there, they would have about 5, which are non-RAF matters. Then in the process of dealing with this expedition, that is dealing expeditiously with case flow management, one would start first with matters which have been, for example, if it's an RAF matter, settled. Then you know that if you go draft order, then you quickly dispose of those matters. There are instances where there would be removals of matters from the roll for a variety of reasons. And one of them might be that the matters are not trial ready. And what do? The other issues will find that there are no property discovered, matters are not properly discovered. In other words, there are no discovery affidavits, especially for the plaintiff. Such a matter cannot proceed to trial. And that is one thing. And the matters which, fortunately, under the amended Rule 37 of the Uniform Rules of Court, one is able to immediately engage on a process of mediation. And for parties who came at each other's throat at 11:30 after you've made some few interventions, then you are provided with a settlement or a draft order settling the matter in its entirety. So those are some of the tactical skills that I've employed whilst I was acting. And not only that, even now as a judge, after having been not relieved, because that may give a different impression, after my term has come to an end, then the JP is, because for the purpose of that call, I'm one of the senior judges. I know some people might think that one is senior in terms of protocol. Yeah. Then I've continued even now from January, when we reopened to date in the second term that I'm still in charge of the role. But the matter does not end there. I have represented the JP in the Judicial Case Flow Management Committee, consisting of various heads of court in the country. Previously, it was headed by the late DP Mtiani.
Yes. Judge, I don't want to interrupt you. If you just give me the highlights because of
Yes.
time, I'm just
Yeah, okay.
sensitive to that. But
Okay.
I've got the 2 or 3 issues you mentioned now.
Oh, all right. No, the other thing is I'm one of the members of the Performance and Monitoring Committee, a committee responsible for the overall performance of the courts, both in Polokwane and Thohoyandou. So that requires a great deal of experience in terms of how you encourage your colleagues to deal with backlog, both criminal as well as civil matters. And with regard to enhance case flow management, I have actually proposed to the JP, for example, in the past, that some of the portions of the practice directive, in order to alleviate backlog, had to be considered. Example, matters which fell within the magistrates' regional court monetary jurisdiction were all discouraged from being enrolled in the High Court. Initially, because they made our court to swell up to 80 or so unopposed motions. Then what we have done, we have proposed that those matters should be transferred to the magistrates' court where they belong, because they're justiciable there, without really dismissing or striking them off the roll. Now, over the years, the practitioners have complied. They no longer issue process with money below the that is really justiciable in those courts. Again, and I must say that after having done so, the JP initially issued a directive, and guess what happened, Commissioner? That directive later received the attention of the full court in Pretoria, who followed our example, and they produced a judgment that such matters should be rather not be entertained in the High Court. And all cancellations, for examples of motor vehicles of people who were defaulted in paying, were all referred to open court. And after having realized that people have turned this court into a debt collection agency, then we have set the registrar in terms of Rule 35, Sub-Rule 5B of the Uniform Rules of Court, could summarily deal with those matters without referring them to court. Okay. And the court became. Those are some of the proposals I've made, and I will continue to make.
No, thank you very much. You've covered my next question, which was going to be, because there was a candidate earlier who wanted to be a DJP and he didn't know what the role of a DJP is. But I think that some of the examples that you've given cover my next question. Thank you. Thank you, thank you, CJ.
Thank you so much, Commissioner. Prof?
Thank you, CJ, but I'm covered, thank you.
Thank you. Honorable Malema?
Thank you, CJ, I'm covered.
Thank you. Advocate KNC?
Thank you, Chief Justice. Good evening, Judge, again. There is a matter that has been drawn to my attention. It pertains to a judgment which you delivered on the 1st of April 2021, so very recently. If I could try and trigger your memory, and you can let me know if you need more detail or whether you can recall the matter. It pertained to a firm of attorneys practicing in your division against whom winding up order was granted, and you gave urgent relief, preventing the winding up proceedings from progressing and halting a Section 417 inquiry. Can you recall the matter? May I ask you some questions about it?
Yes, I do recall that matter.
Thank you. I was given a copy of the transcript yesterday, and I'm sorry that this couldn't have been delivered to you before I ask you questions, but maybe you'll recall. What appears to me is that on the 31st of March, you heard argument on the question of urgency, and then you stood the matter down in order to come to a decision on the issue of urgency.
Yes.
And you informed, and it's on the record, you informed those in court that you would only be dealing with the issue of urgency overnight, and that you would give a ruling on that issue the following day.
Yes.
And that all that was required was for legal representatives to be present the following day to note the judgment. And that was in fact clarified with you. The specific question was asked that whether the legal representatives need appear, and you said, no, you don't have to, you can send correspondent attorneys to note the judgment.
Yes.
Now, on the following day, you handed down a judgment in which you found on the issue of urgency. But what you also did is you went on to give substantive relief on the merits. You gave interim relief in favor of the applicant. The relief was for a period of 7.5 months because you said that the applicant could come back to court in mid-November, if I recall correctly, to address whether that relief became final. But then you also gave final cost orders in the matter. And those final cost orders were also against the commissioner in the Section 417 inquiry, who had not opposed the relief. He had said he abided by your order, and nobody in court or on the papers had requested that costs be granted against him. I would like you to just address us, please, on that issue, that why it is you gave interim relief, not having heard argument on that issue, why it is you did so in the absence of the legal representatives, and why you gave final cost orders when you hadn't heard argument on that.
All right, firstly, Commissioner, it's a pity I haven't been provided with the transcript for me to peruse and to verify.
Yes, I did acknowledge that.
Yes,
and
but then
apologize for it. I only
I'll
received it
endeavor.
yesterday.
I'll endeavor to answer your question.
Yes.
The matter before me found its way in my court by way of agency. And from the word go, I've asked counsel in the nature of the things as they were, and given the agency of the matter, because the commissioner consent appointed under the Insolvency Act provided or rather delivered a notice to abide the court decision. In other words, did not participate in the proceedings pertaining to agency. But to my surprise, on the very same day as I was sitting in the Asian court, the Honorable Commissioner, a judge for that matter, despite the fact that he filed a notice to abide, proceeded with the inquiry, the insolvency inquiry against the applicant. And that to me left me with the impression that first, the matter is urgent because now the relief he seeks is that he, as a commissioner, should not be proceeding with the inquiry pending the outcome of the main application. So the matter before me was not dealt with on the merits, but only issue of agency was considered, and which is why I issued a rule nisi. But with respect, Commissioner, I do not appoint dates, especially in opposed motions. Dates are being provided for by the register. Now, the date of 7.5 months, as you've mentioned, it was not out of my own making, but that is what I've been provided for, that the rule nisi is returnable somewhere in November. I can't remember the date for now. Now, turning to the issue of costs, indeed, the notice of motion was such that the costs be paid.
Judge, with respect, could I draw your attention to the part of my question? You had not heard the parties on the merits. You had excused the legal representatives from court, and you had stated you were only going to rule on the issue of urgency.
Yeah, let me respond to that one. And I think I repeat for the sake of emphasis. I have asked counsel on the day of the hearing of the matter that we shall not be digressing into the merits, but we're only going to focus on agency, because the nature of the relief sought was such that it could not wait, because by the time merits are considered, the whole thing shall become superfluous. Now, for that reason, I have decided, and with the consent of counsel, that let's not focus our energies on the merits, because the merits will also be dependent on the outcome of the inquiry that is taking place there, which the applicant sought to restrain in those insolvency proceedings. And given the facts asserted in the affidavit, explicitly setting out the agency, I became satisfied that the matter was sufficiently urgent, and therefore I granted interim relief. The position would be somewhat different if I granted final relief. Then that will be a matter for concern for me. In
Judge,
other words,
I'm not permitted any more questions. We're under strict time restraints. But I will, in fairness, say to you that the issue of granting interim relief is what I'm referring to as the merits. That was the merits of the application before you. You agreed that you had not heard the parties, though, on the issue of whether to grant interim relief. When we say the merits, we're talking about interim relief. Are we ad idem in that regard?
Commissioner, the nature of the relief granted was not finally dispositive of the issues, which otherwise fell within the parameters of the merits. So therefore, I do not really understand what your concern is, because that issue, which is why it was granted as an interim measure, it did not lead to final dispositiveness of the matter. So if the merits are still going to be heard in November, so there's no prejudice. The door is not shut.
In other words, if I understand your answer correctly, you are entitled as sitting as a judge, or you would consider it proper to give interim relief without hearing the parties on the question of whether you should give interim relief.
The council were present, both for the first and other respondents were there, except Judge Battersman, who was a commissioner at the time. Now, the point I'm making is this: counsel were heard not on the merits, but purely on agency. They were present in court. It was not in their absence. And we agreed that
And Judge,
do not digress into
the-
the merits, because as matters stand, this matter was such that it could not have awaited until the next available opposed motion date, or post-motion date. It would have become academic for the applicant. It would give him cold comfort, even if he wins thereafter, because the role of the commissioner, as we're busy hearing these matters on an agent basis, he was busy there with a private inquiry. But in the same breath,
And it-
having delivered a
may I
notice,
just
having
ask-
delivered a notice to abide. You see, that's what really
Yes.
made me flabbergasted.
And is that the reason why you granted a costs order about Bertelsmann without hearing him at all on that issue?
Well,
Final costs order.
well, I can't remember whether I could have granted final cost order against when I say the matter was just on interim basis. It's a pity I don't have copy of that
Could I
transcript.
read your order to you? May I read your order? The last part of your order is that the first to fifth respondents.
This is probably the fifth or so question. Do you want to tie it up? I can see you feel
Thank
strongly
you, Chief
about
Justice.
maybe just the last question.
Yes.
Really.
All right. Thank you, Chief Justice. Thank you for the indulgence thus far. Judge, you granted a final cost order against 5 respondents jointly and severally. Included in them was the judge to whom you've referred. Will you agree that you did not hear them on that issue?
Initially, all the respondents had opposed, filed notice to oppose. It's only on the day of the hearing of the agent application that notice of to abide. So plaintiff was put, rather, applicant was put at, how can I put it, in a position where he had to engage counsel, attorneys to brief counsel, and counsel ultimately to come to Polokwane from Pretoria or Johannesburg. So those were expenses. If a person wants to abide, you do so in advance because you've been served with the papers. You don't just drop a
Judge,
paper today.
I will leave the issue there.
Yes.
In the interest of time and because the Chief Justice has asked me to wrap it up. Thank you. Thank you, Chief Justice.
Thank you, Commissioner Kane. Commissioner Barna?
Thank you, Chief Justice. Good evening, Judge Patudi.
Good evening.
I just want to confirm with you, the MG Patudi Incorporated had a trust account as a law practice. Is that correct?
It had, yes.
And on what date was that trust account closed? The banking account now?
Yeah, it was closed shortly before the end of June 2016.
Because it seems to me that the MME Patudi, or your spouse, I think, became a director on the 7th of April 2016.
Yes.
If I look at the document you provided.
That's correct.
So the trust account was still continued by the incorporated after there was a non-attorney or non-legal practitioner as a director of the firm.
By that time, Commissioner Barnard, having received the news, I'm not sure whether was it on the 4th or 6th of April in 2016, news from the JSC that you've been recommended for appointment. Then I immediately knew that I had to begin with a system of liquidation so that by the time the 1st of July comes, the trust account is 000. Now, from that moment of the 6th of April, the practice was not receiving money anymore in the trust account, which is why it left a zero balance end of June. There's a letter to Law Society to that effect. It's just that in the interest of time, but I think I have a copy somewhere.
Thank you, Judge. Thank you, Chief Justice.
Thank you very much, Commissioner Barnard. JP Mlambo?
Thank you, Chief Justice. Robert.
Yes, Commissioner? Okay. Commissioner, thank you very much.
Are you okay?
Yes, I'm all right.
Good.
Yes.
Just to follow up on the question by Commissioner Kane. To me, the question is simple. You agreed with her that you stood down the matter to determine the issue of agency.
That's to make, yes.
Now, usually in
To
an
make
agent
a,
application.
sorry, to make a ruling the following, because it was very late.
Yes, but on the issue of agency.
That's correct, yes.
Yeah. So usually the order sought in an agent application is the first order sought is an order that the matter is urgent.
Yes, that's correct.
And then other orders follow.
Yes.
So I think the number of the questions that you were expected to make a ruling on the first prayer sought agency.
Not only that, because there were other things in the, rather prayers in the notice of motion.
Okay, no, I was
But
just
which
explaining to you that that was her question to say,
okay.
when you stood down the matter, you knew what orders were sought, but you
Yes.
said we won't go into any of the other things. Let's check first whether
The matter is
I
urgent.
agree if the matter is urgent.
Yes,
You agree with that?
that's correct.
And the question was, the next day, you not only issued an agency order, you went further and issued other orders, including cost orders. And the question was, why did you do that?
All right. No, it's because JPD, the answering affidavits were already there. The parties came to argue agency, and that is why at the end we had to say, all right, now the costs are being granted, and the rule is also granted, and the costs are granted because they were opposing even the agency itself.
Okay, no problem. I won't belabor the matter. I'm putting these questions in fairness to you because I put them to Judge Mudau.
Oh, I see. Okay.
The first one is, do you subscribe to the view that you applying for a leadership position, so as a leader in the judiciary, you've got to be proficient as a manager, administrator, as well as a jurist of note?
I agree.
Do you have any judgments that you can, out of memory, that you have written that have gone to the SCA, been upheld, or even gone to the Constitutional Court?
Yes, I do have. May you allow me an opportunity to?
Now, if you've cited them in the application,
Yeah, they are
just say
there
so,
in
we'll
the
find them.
they are there in the questionnaire, Chief.
Because I couldn't see the indication to whether those judgments went to the SCA or went to the Constitutional Court.
Yeah,
But if you say they are there, I take your word.
Yes, JP. There are those which I've marked that they were upheld, and then those which someone tried to appeal.
Yes.
And were dismissed. I think I've listed them there in the questionnaire.
Okay, now I take your word for it.
Thank you.
It's late in the day after all. The last question, that was a follow-up, CJ, sorry. The last question is, you've mentioned that you've represented the JP in, I think you said case flow management meeting. I think
Judicial.
you're referring to the PEEC, are you not?
It's JCFM.
The JCFMC?
Yes.
Okay. But do you agree with me that the biggest problem in our judicial system are the unending matters, the backlogs in terms of trials that never end, especially those in the regional court?
Yes, I am aware.
Now, as a judicial leader with a responsibility in terms of Section 8 of the Superior Courts Act, what do you think we can do to address that problem? Because it's a big problem. Some trials last longer than 5 years, sometimes 8 years.
Yes. Some of the very same concerns you raised, JP, are contained in this report, which I have sourced from the regional office, dating back, it says it's 2019. Now, in terms of Section 8 of the Superior Courts Act, indeed, as a deputy to head of court in the province, the first would be to make sure what are the causes of these backlogs. I've already intimated earlier on that incessant power cuts, electricity, shortage of water, intolerable working conditions in the courtrooms and so on, overworked legal aid officers and related matters, all impact negatively on the speedy finalization of cases and hence the backlogs. Now, what do you do to address that problem? Is from time to time for one to visit the areas, see the state of repair of those infrastructures, and at the end of the day, come up with solutions. And what will be the solutions is what the minister earlier on raised. I said, having a formal contract between the Department of Public Works and Justice.
I think I was asking you as a leader what you could do. I think you've answered the question.
Yes.
What you would do as a leader.
That's what I would do, yeah.
Yes. And Chief Justice, I'm done, but just to clarify to the candidate that the magistrates' court matters in the high courts, that matter in Gauteng, it's the Tobejane versus Nedbank matter.
Yes.
It was not arising out of a directive issued in Limpopo. It was a directive issued in Gauteng. And the country still waits direction from the SCA in that matter. Thank you, CJ.
Oh, I wasn't always appealed against.
Honorable Klaba.
CJ, I had forgone my slot after you had granted me permission to ask a follow-up question. Thank you so much, CJ.
Thank you, sir. Commissioner Sigogo.
Thank you, CJ. Judge.
Yes.
The Limpopo High Court has two local divisions. Currently, it is only one local division which is operating, which is Thohoyandou.
Yes.
Which is just less than 200 kilometers away from the main seat, which is in Polokwane. If in your thinking, what do you think? Should the JP and the DJP sit in the same court, or should they be in different courts? And why?
Well, given the capacity of the court in Thohoyandou, as you might be, as you know, it has only 3 courtrooms with 3 chambers, and it's a very small establishment which was created in terms of the old law of establishing Venda as a republic. So for now, even if a DJP were to sit in Thohoyandou, there would be no space. Those judges who are sitting there have their seats permanently established and they're anchored there in Thohoyandou. To rotate them, for example, to say the DJP should shuttle between Polokwane and that, ideally it would be a good proposition. But practically, in terms of financial constraints, that is a bit of a problem. And that is a matter that even the JP himself will not be able to deal with. It requires a lot of finance. And as you know, nowadays money is a scarce commodity. So that's number one. Secondly, because of the shortages of the judges in Polokwane already, to remove a DJP to go and sit in Thohoyandou, you'll be creating yet another loophole. Given the fact that there is a lot of work, the work volume there it's so high that if you detach one of the judges to go and sit any other place, for example, even Lephalale, where I know it does not yet being operational, but the day say you need a week or 2 of judges sitting there, then the system becomes compromised.
Thank you. That we will take it outside this forum, and we will engage. But this question I asked the previous candidate. I'll also want you to answer. Limpopo has one female judge.
Yes.
As we speak, and has a male DJP, a male JP. And this position which we are interviewing for is replacing a female judge. I would like you to share with this commission as to how you, and one of the candidates is a female.
Yes.
And how your appointment to the position will enhance transformation of that court.
Okay. Now, the answer is this. Firstly, the appointment of judicial officers is regulated by the provisions of Section 174, subsection 1 of the Constitution, and also subsection 2 thereof. Let me approach the question as follows. First, I'm in favor of females, judges being appointed to the judiciary. That's very clear, no compromise about it. But any other female who's coming in, not necessarily being a replacement of the one who exited, I would appeal to that question to say there is a constitutional guideline which is provided for in Section 174, subsection 1, which says every male or female who is suitably qualified may be considered for appointment as a judicial officer. Any other candidate who happens to be a female, who's aspiring to the same position, not only in this division, but any other division, or even in higher courts, positions of management, then the provisions of Section 1742 kicks in the sense that there is an element of racial balance as well as gender. The two cannot be read separately. But the matter does not end there. You have to read 174 together with Section 9, subsection 2 of the Constitution, which guarantees equality, equal treatment by the law, as well as equal protection by the law and equal protection of the benefits associated therewith. Now, if one were to say, because a female has exited a particular position, would it have an indication whether or not to enhance gender or to enhance transformation, let me put it that way. I would say that both male and female should be treated equally, be it whether, especially when they belong to a particular previously disadvantaged group. I think that was the purpose of the lawmaker there. But not only that, you do not take any other female merely because it happens to be a female and put such a female in a position of management, unless that female is suitably qualified, equipped, and has amassed sufficient experience in court management. Now, let me give an example. If we still have time then, the Chief Justice, the position is, assuming a particular candidate has been a prosecutor in a district court, or somebody has been an attorney in private practice, whose sole responsibility was manage that environment. And then you have someone who happens to be a magistrate, but a chief magistrate, who has under her a cluster of people whom he or she manages. Let me say she in this case. And then she wants to aspire to become a judge president, deputy judge president. Then that's where there must be a balance, not only of the race, the gender, but suitability. It's no longer a question of entry point, because that has already been achieved under section 174, subsection 1. But then 2 has its own dynamics. The needs of the court to be managed by someone who comes with demonstrated experience in management of the court systems. And that would, of course, at the end of the day, tip the scales in favor of such a prospective incumbent.
Chief Justice, may I do a follow-up?
Yes, please.
Thank you. You indicated that you are going to be 5 years on the bench July this year.
Yes.
And when I check, the female candidate who is as well contesting for this position was appointed to that court hardly less than a year after you were appointed. So, which means you are not appointed more than a year before her. So, to me, if we are to talk about high court experience, you are not far away from each other. And the other issue which I would want to engage with you is the example that you gave, that you, and I believe you as a man, a black man, and her as a black woman, you are in the same position in terms of
racial balance.
Racial balance.
Yes.
And I thought, in terms of the Triple B Act, black women are the first to be considered, or are the ones considered the most affected by the past atrocities, and then black men are not in the same level as black women. What is your comment to the two issues?
Yes, one should carefully distinguish between the requirements laid down under the Procurement Preferential Framework Act, which tends to deal, when you consider issues of BEE status in either procurement or other tendering system. That would be a primary consideration in terms, if there is contestation between a particular bidder, for example, led by a black female and a black man. Let's say their own functionality on pricing and capacity, the scales are tipped equally. Then that's where, strictly speaking, in terms of the Procurement Act or measures framework, then that question would arise. But the judiciary is something else. There's no question of business here. We're talking about capacity to demonstrate experience and knowledge. And you want to say there's a difference of 1 year apart. But we don't look only at that. We look also at what has a person been doing before appointment as a judge. Because you'll agree with me, Commissioner Gogo, that life does not begin when one becomes a judge. There are other things that one has done before. Managing institutions on behalf of government, the road agency in Limpopo, for example, I became the first executive chairman, non-executive chairman. I'm just giving you an example. And many other parastatals that I've led in leadership position. Then I brought that into judiciary. And again, in contradistinction to what I've said in terms of section 1741 and read with subsection 2 thereof, where a person, for example, has not had occasion to be exposed to act and serve in management of the judiciary. And I'm not casting any aspersions here, but I'm purely trying to address my question. He who has acted, or the person who has acted, will have an advantage because we are talking about service delivery to the people. You see?
Well, maybe while you are there, Judge, as you are still answering and rounding up, you are 7 months apart as judges, and she has acted as the head of a magistrate's court. She may not have been afforded the opportunity to act as deputy judge president, but she served as the head of court. Maybe you want to include that in your answer.
Oh, yes.
Briefly.
Yes,
Briefly.
thank you, Chief Justice.
Judge President, just on a point of order, can we just set a principle here in this specific issue?
What point of order now?
Just a principle here that, I mean, on an issue of principle.
No, there is no problem, ma'am. Let the judge answer. I didn't want
I'm very uncomfortable with this.
If the judge is well able to defend himself. Judge, please, I'm sorry to have interrupted you. I was including the issue of head of court so that I don't come later about it because you're dealing with the same question.
May I proceed?
Yes, please.
That is understood, Chief Justice. But then being an head of court in a magistrate district, one operates within a limited space in that district. But if someone were, say, a chief magistrate, for example, would under that chieftain, under that position as a chief magistrate, then you have got cluster magistrates accountable to yourself, and that would really translate the holder of that office into someone who has amassed experience. But if you only being a head of a particular district, then I do not think, in my view, that that can be compared to a person who heads the whole province as a judge president or deputy. There's a great deal of distinction there. Because I remember that under Section 8, if I may add, of the Superior Courts Act, the head of court, usually the judge president, also takes responsibility over all magistracy established in his area of jurisdiction. That's my submission.
Thank you,
Mr. Skogo.
Commissioner Sigogo, are you done?
Yes, thank you, Chief Justice. Thank you, Judge.
Thank you.
I should attest to your love for legal education. I know I attended one of the courses that you have offered. Thank you.
Thank you.
Thank you very much, Judge Aduri. You are excused.
Oh, thank you very much.
We're sorry to keep you waiting for this long.
No. It's all in the game. I know. Actually, I expected to leave here 10 p.m. Thank you, Chief Justice.
Sir.
Thank you.
Thank you.
Are we on a commercial break? Oh.
Chief Justice, Judge Semenya is here, she's waiting.
Thank you, sir. I had a little challenge. I'm sorry to keep everybody waiting. Good evening, Judge Semenya.
Good evening, Chief Justice.
If you are comfortable, you may take off the mask, but if you prefer to have it that way, please keep it on.
Thank you. I will remove it.
Are you well, ma'am?
A bit nervous, Chief Justice. It
Oh,
always
yes.
feels like
Oh,
the
yes.
first time.
Oh, yes. No, we apologize that instead of bringing you here at 2:00, as indicated on our program, it's only now that you're coming here. Please bear with us.
I will, Chief Justice.
Thank you. For how many years were you a magistrate?
For 30 years, 32 years, Chief Justice. I
32
have been a prosecutor from 1985 up to 1991, and thereafter was appointed a district court magistrate up until 2003 when I was appointed a senior magistrate. I was thereafter appointed in the regional court until when I came here in the High Court.
And
it is actually
at
26 years as a magistrate, Chief Justice.
Okay. And at some point you were appointed to act as head of court. How long did that last?
It lasted for a year, and thereafter I was appointed a senior magistrate and head of court at Seshego.
How big is that court? It was just Seshego. You were not a cluster head, no.
I was a cluster head. I was head of Seshego and head of Seshego cluster, and Magistrate Mukopani, Magistrate Mukerong, Magistrate Bochum were reporting to me.
How many magistrates were in that region or district or cluster that you were heading?
There were 14 magistrates.
Yes. And apart from heading that court, have you ever assumed a judicial leadership role elsewhere?
No, only in Seshego and acting as a senior magistrate at Mukerong, I was head of court. And also as this cluster head. It was a leadership position.
Cluster head for how many years?
I was it was actually not cluster head, but sub-cluster head.
Yeah, because the cluster head is responsible for the whole province.
Yes, and the province is divided into sub-cluster head divisions.
That's right.
Yes.
That's right. Yeah.
So I was there for a year.
Okay. And for how many years have you been a judge now?
It's 4 years.
4 years.
Yes.
And what would you say has given you the confidence that you are ready for the position of Deputy Judge President for you to have applied? Just very briefly, we can say because of this, that, or the other thing, I believe I'm equal to the task.
The Polokwane High Court is a small division. It has 6 judges, excluding those who are at Thohoyandou. And as a result, we did not have a specific job to do, if I may say so. We almost did everything because our JP said that because of the shortage, even if you are allocated to do work in the criminal court, make sure that whenever there is a need, like for instance, if your court collapses, don't just sit there and say your court has collapsed. You must go to other judges and ask them if they have any file that they can allocate to you. As a result, I did almost everything except allocation of matters. And this allocation of matters is something that I was doing as head of court in Seshego at the time when I was still a magistrate.
JP Makoba, over to you.
Thank you, Chief Justice. I do not have any question for the candidate. Thank you.
Thank you, sir. And just before I call Mr. Singh, may I just get a sense of which colleagues would want to put questions to the candidate?
Dodovu.
I do, CJ.
Nyambi.
Wait a minute.
Did you catch my name, CJ?
Honorable Dodovu. No, I didn't, ma'am. It was.
I spoke first. Maya. Then
okay.
That was me.
And then after it was you, and thereafter it's who?
Nyambi.
Is it you, Honorable Nyambi? Do we have another colleague who wants to?
Matolo.
I didn't get the name.
Matolo.
You were
Matolo.
Chief Justice, the other Singh after Nyambi.
Lamola, Chief Justice.
Tepe.
CJ.
Sorry, Jenny Kane, please.
Malema, please.
Schlemmer, please.
JP Mlambo, CJ.
Thank you. Mr. Singh?
Thank you, Chief Justice. I too do not have any questions for the candidate.
Thank you, sir. Honorable Dodovu?
Yes, just 2 quick ones. CJ, good evening, Justice.
Good evening, Commissioner.
Good. Just looking at your CV, you became a prosecutor at the age of 23 years, and that was in 1985.
Yes.
As a young woman then operating within the environment pre-1994, what do you think is your experience in terms of issues that are challenging women today?
Thank you. I will always cherish my position as a prosecutor because it is that position that taught me that to succeed in this position, or in the legal field, you do not only require IQ, you also require EQ, being emotional intelligence. Because without that, you will not survive. In the first place, remember that it is that position where you come in close contact with members of the community. And when I say members of the community, it will be a mixture of members of the community, the poor, the rich, the arrogant, the angry. And if, for instance, it is in a maintenance court, you must find a way of talking to those people, and you must make sure that when they get out of your office, the woman will come out holding a maintenance order. You must, and that emotional intelligence will also help you to deal with criticism. Because everybody will throw whatever type of criticism to you, and you must remember that, always remind yourself that you are here to play the ball and not the person. I will cherish that position.
Okay, no, it's okay. In the
made
interest
me
of time,
matured.
it's okay. Now, you were managing the court at some point. I link this question with the first question. In the face of that, what were you getting from men who sometimes, like myself, we have our own stereotypes about women. Now, as a manager of the court, managing people and doing the work in that sense. I'm asking this because you have applied for a position as DJP, where you are going to manage people. Yes.
It was not only that. I was also the youngest of them. I will be the only female and the youngest of them all, to the extent that I will be managing magistrates who have long been appointed before me. Some of them were appointed when I was still in high school. But the first thing that I would remind myself is that I am not dealing with men per se. I am dealing with magistrates. I will respect them as males. I will respect them as colleagues. But they must also respect my authority. It is the office that they must respect. And I always, somehow I managed to earn their respect.
Yes,
And if I give you work to do, I will be doing that because the position that I am holding requires me to give you work. And you must know that you are not actually working for me, you are working for members of the community. And for instance, there are over and above that, there are mechanisms in place. We have codes of conduct. I know what to do if you are adamant that you are going to undermine me. I will follow the route that has been placed in. Put in place
Thank you
for
very
this.
much. I like your spirit. Thank you, CJ.
Thank you very much, Honorable Deputy. President Maya.
Thank you, CJ. Good evening, Judge Semenya.
Good evening, President.
I just want clarity on your leadership experience, both in the NPA and in the lower judiciary. You were a control prosecutor supervising other 4 prosecutors for how long?
It was for 2 years because I arrived at that office in 1985, and there was a lady prosecutor. She was our control prosecutor. In the past, it was in Elubua government. We only had one senior prosecutor who was stationed at head office, and at district levels, we had control prosecutors. I will forever be grateful to that woman because she is actually the person who introduced me into the field, who said to me that, you know what, they are our colleagues, you must never be scared of them. I will forever be grateful for that. But after she left, she was later appointed a head of office at Namakhale. And I remained at Mugerong, and I then became control prosecutor.
How did you cope with the responsibilities that came with that position?
As I said, I developed emotional intelligence from a very early age. And then it is only one prosecutor who was appointed before me, but the others were appointed after me. And we shared the job. We just shared files. We made a timetable. This period, this prosecutor will be prosecuting cases in court. These ones will be communicating with the Attorney General, making reports to the Attorney General, and also deciding on cases whether they should proceed for trial or decline to prosecute. So we always shared work equally for that matter because we were rotating. If I am in court for a month, the next month I'll be doing the decisions, communicating with Attorney General, preparing cases for high courts and so forth. I coped very well in that. My modesty is also helping me. By modesty, my humility and so forth. I have to be that because otherwise it would have been a very road to travel on.
And thereafter, for a year, you became an acting head of court and cluster head. That is in 2003 and 2004.
No. In 2003, I was appointed acting head of court at Mugerong. It was for a year because thereafter a post of a regional court was advertised. I applied for it and I was appointed in 2004. So I only acted as head of court at Mugerong for a year, and not regional court. I only acted for a year, and I was thereafter promoted to a senior post and head of office, head of court at Seshego. I moved from Mugerong to Seshego.
And thereafter became a regional magistrate for 12 years.
Yes.
Now, did you do this
and also as a regional court magistrate, I was the only one at the establishment, Magistrate Mugerong. I was the only regional court magistrate, but I had to do cases also at Mokopong, at Modimolle, at Lephalale, Bilabela, and Tabazimbi. So I had to man all those courts on my own.
A concern has been raised that you have not had opportunity to test your capacity as a leader of the higher judiciary now for the position that you seek. Why do you think that this experience you have that you've just recounted will help you, cope in this one that you want us to recommend you for?
I always believe that when it comes to leadership, you are a leader or not, and also it requires not only IQ but also EQ, as I've already stated. And yes, I was managing the lower courts, but the job is almost the same. It is only that in the high court, you are doing it at a higher level. Now, the relationship you have with your colleagues will determine whether you are good for the job or not. And so far, I didn't have any negative relationships with any of my colleagues. And also, because I also respect, if they allocate cases to me, I don't say no, I don't want to, unless I am pressed. I cannot do it for a valid reason for that matter. It's leadership in the lower court, but yes, I think my experience in that position will also assist me greatly, despite the fact that I haven't yet acted in that position.
Do you know what responsibilities you'd be tasked with in this job you seek?
Yes.
And what challenges there are in your division?
Yes, I do. And I also appreciate the fact that, as I've already said, that I was introduced by a woman in the lower courts. I was also fortunate to be introduced by another woman who was in the position in which I am being interviewed for. She took me by her hand and by my hand, and she worked closely with me as if she was preparing me for this position.
Would you just be a little more specific about the nature of the responsibilities that you'd be expected to take care of as a deputy judge president?
One of the responsibilities is allocation of cases to other judges. And also to see to it that case flow is properly managed. And also one important thing also is to realize the strengths and the weaknesses of your colleagues. And by saying this, I mean that you will know as a manager that this judge is good with criminal matters. So whenever there is a backlog in that court, you better utilize that judge to reduce that backlog. You also know who is good at a motion court or post-motion. You know which of your colleagues is good at that, who produces judgment quickly, who is delaying in that regard, and who is sensitive to issues of women, who is sensitive to issues of children. You better know your people. And that is what she introduced me to: allocation of cases, management of case flow, and seeing to it that cases are finalized within the required norm and standards.
Sorry, did you speak, CJ?
No. I was about to caution you that they are becoming many now. If you could be the last case.
One more, CJ. Concerns have been raised about your readiness for this position. I think it's the Society of Polokwane Advocates that say you need a bit more time to develop your legal skills. And then there's another body that that says pretty much the same thing, that you just need a bit more time as a judge, before you undertake a leadership position. What would you comment how would you respond to those comments?
I'm ready. And with Society of Advocates, I take cognizance of the fact that they concluded their comments by saying that they know very little about me. I don't actually know how to respond to the statement because I've been in that court for 4 years. And I've been in court almost every day of my working life in that division. So they in a way, make comments, negative comments about a person, and admit that I do not know that person. If I was the scribe, I would have said, I know very little about this person, I therefore cannot comment. But my track record, especially in management positions, speaks for itself.
Thank you,
And
Judge
yes,
Oh.
the remarks are the same. And I fail to see how 2 more years will assist me in that regard.
Have you finished? Thank you, Judge Semenya.
Thank you.
Honorable Nyambi.
Evening, Judge Semenya.
Good evening.
As the only female judge in that division, if you can share with us your worst experience being the only female judge in that division and how you were able to deal with it.
I'm used to be the only female in the establishment. I'll be lying if I can say I have been negatively affected by being the only woman in that division. I am used to it. Throughout the years, I have developed skills to deal with such things. As a result, I'm sorry I cannot point one little thing that I can say it affected me.
That's fine. My last question, if you can share 2 attributes of a good judge, and please focus on those that you think you possess that will come handy and assist you as a DJP in Limpopo.
The first good attribute of a judge is impartiality. And it goes with what I've already said, that concentrate on playing the ball and not the person. And the second thing is to be approachable. Mainly, especially by those that you are working with. And when I'm saying this, I'm talking about court support services, because without a good support service, there is nothing good that is going to go in that division. So it is, and also, as I've already said, emotional intelligence is very important.
I'm more than fine. I wanted two, you gave me three. I hope it's those that you possess.
Yes,
Thanks.
I do possess them. I do possess
Thank
what
you.
I have already said about.
Thank you, Judge Simenya. Thank you, Chief CJ.
CJ, please.
Thank you, Honorable Nyambe.
CJ, please
Sorry.
add my name, Sred Klaba.
Okay. To include your follow-up.
We don't hear you, CJ.
Commissioner, or is that follow-up?
No. Your network got interrupted you.
We didn't hear you, CJ. We thought Matlo was around.
Can you hear me now?
Yes,
Very
CJ.
clear, CJ.
Okay, I wanted to find, okay, so Honorable Klaba was not seeking to be included.
Just to be included, CJ.
Oh, thank you, sir.
Thanks,
Thank you.
thanks, CJ.
Commissioner Matolo Dlepu.
Thank you, CJ. Good evening, Judge Semenya.
Good evening, Commissioner.
You know, one of I'm happy that you are a woman in that division where it's only males, and I want to encourage you to soldier on and make sure that other women come with you.
Thank you.
Because we need really to diversify.
Yes.
You know, make sure that women are represented. But what I wanted to find out from you, that's my question. You know, we had a previous candidate saying that the magistrates in Limpopo need training, and you come from the magistrates. Do you think the situation is so dire that they cannot have magistrates from Limpopo acting as judges in the High Court?
No, I cannot say that, because you can see when you read judgments, remember that their judgments come before us on appeal. They come before us on review. You can see how they structure their judgments, that most of them are well-reasoned and well-written. And I take it upon myself that should I be recommended for this position, and having worked with them for so many years, I will, with our judge president, because I will still be under our judge president, who is also a hardworking judge president, there's no doubt about that. I will liaise with him and take the judgments that come before us, and also ask other judges in the division that should they come across any well-written and well-reasoned judgment, and it is not only about the judgment being well-written or well-reasoned, even conduct of the proceedings itself, how the proceedings are conducted from the beginning up to the end, the speed at which they are done, how he interacts with all who are taking charge of the court is very important. How he or she addresses the parties that are before him or her. How he addresses the witnesses. Remember that these are most of them, especially in Limpopo, it's rural. It's rural. You can imagine the type of community that magistrates are serving. So I will just ask my colleagues, if you happen to come across somebody who, according to you, is fit and proper to come and act, let the JP know about that person. And if possible, ask him to give this person an opportunity to come and act. One rotten potato cannot spoil the whole bag. There are good magistrates out there.
Because one of the concerns, sorry, CJ, because I know that there are a lot of trial advocacies, BLA offers those, so I was quite worried that the situation is there, that we can't have anybody to appoint.
No.
Okay, thanks. Okay. And thank you, Judge.
Thank you.
Thank you so much, Commissioner Zeppo. Honorable Singh.
Thank you very much, Chief Justice, and good evening to you, Judge Semenya. I think you are aware, as we are, that as commissioners, when considering appointment of judicial officers, we have to be mindful of section 174(2), which speaks to gender.
Yes.
But I do not believe that gender on its own should qualify one for appointment. Therefore, I'm going to borrow a word from the Chief Justice, if he does not mind, and I'll tell you what that word is just now. You've got a checkered career in terms of law, 36 years or so in the practice of law. You've had some management functions and tasks. But can you brag about, and that's the word I'm going to borrow from you, Chief Justice, which you did not use. Can you brag about your administrative abilities and give us some examples where you stood out in administration of whatever in your career? Thank you.
Administrative, may I ask what?
I think
May I seek clarity as far as
management
administrative matters are concerned, yes?
Okay. Yeah, you've heard the word management being used. This is not only an appointment which is going to test your legal skills, but also your ability to manage a team. And you did say to us there's a team there where you are currently. So we just want to hear about I want to hear about your administrative abilities, and you can brag a bit about it.
Okay. In the past, in Leboa, magistrates were actually the ones who were in control of the entire court. And remember that during that time, especially in Leboa, all offices were within the magistrate's office. So that will be Transport Department, it will be the present SASA. We will also have accounts office. Accounts office is that is where they run, where they deal with money. And at the close of every court day, we had to check the court books. Court books are, it is clerks of courts who are entering whatever was necessary to be entered in that court book. For instance, if as a magistrate, you have at the end of the day convicted a person, you have imposed a custodial sentence coupled with an option of a fine. You must see to it that if he pays, clerk of a court did the necessary entry in the registers, and that money actually ended up in the finance office, and that at the end of the the first thing in the morning, that money must be taken to the bank to be banked. We were everything. You must know that. You must know that whatever is done at court is properly handled downwards up until the end. So that, for instance, if that person pays bail, you must see to it that the clerk of court has made the necessary entry. He has attached the bail, copy of the bail receipt, wherever it must be attached, and that when the case is finalized and he is acquitted, whoever paid that bail to him must come and get it when the case is finalized. There must not be a situation where it is said that we can't trace the money that was deposited as bail. We also managed maintenance offices. You must see to it that maintenance orders are entered in the correct register. You must make a follow-up that the person who has been ordered to pay maintenance is actually paying it and not defaulting. We kept on checking the registers. And you must also make sure that whoever is responsible for that must issue summons in case that person has defaulted. And that must be done in time, because if you leave it for long, you will end up in a situation where that person owes 10 times what he is earning, and you will never be in a position to recover that money. And we were doing so in order to avoid a situation where you would be forced to send him to jail because you want him to continue to work, but you want him to continue to carry out his responsibilities. It was only in exceptional cases where you will say that you are you are incorrigible. Then in those circumstances, you'd rather your children, I used to say, I don't know whether other magistrates, I used to say, it is better that your children suffer, your children go hungry because you are in jail, rather than for them to continue to sleep with an empty stomach when you are earning a salary every month. So it is a system. You cannot just say, I finalized this case, that's it. No, we were making a follow-up by checking the registrars, checking clerks of court, checking maintenance officers, checking the registrars of the sheriff as well. So we were all-rounders as magistrates.
No.
Thank
you, Judge. Good financial management there. I wish more people can do that. My second and last question will be this. To an earlier question, you said, when asked of your colleagues and collegiality, you said, so far there's nothing negative. Now, perhaps there is nothing negative because you may not, have a position which they find that they could have occupied themselves. Now, what do you think, if you get promoted to the position of DJP, will you be carrying your colleagues along with you? And have you come to this interview and applied for this position, having the backing of the majority of your colleagues in your division? Thank you.
Some of them wished me good luck. I have them on my, I received messages in that regard. And also, I believe, I have no doubt that they will support me. Up to this stage, I have no doubt, but it's a beautiful profession. It's a beautiful profession in this regard that you cannot just disregard what I am saying simply because I am a woman. You cannot disregard me simply because, as it is now, I'm the most junior. And this thing of saying that only seniors must be promoted to this type of positions is, if I want, for want of a better word, it is outdated, because already we have people who were considered juniors, but they ended up in senior positions and doing well. And I'm saying this because we have the Judicial Service Act. It tells you what to do if a person doesn't want to carry out your instructions simply because he considers you to be his or her junior, or he considers you to be a woman. And I will report. I will not hesitate to report, to use the mechanisms that are already in place, because they are not just, they must be made to be worth the papers they are written on.
Thank you, Judge Semenya. Thank you, Chief Justice.
Thank you, Honorable Singh. Honorable Minister.
Yeah, thank you, CJ, and good evening, Judge.
Good evening, Honorable Minister.
Yeah. Firstly, I can see that you were a prosecutor for some years and you benefited from that experience. What is your view about prosecutors acting as judges or magistrates?
Firstly, it is something that was done in the past. It was working well. We had, it was Section 5, if I'm not mistaken, where, for instance, 2 magistrates are sick and the courts must run. We were using that section to appoint a prosecutor for that period to act as a magistrate. it was not acting as it is now. But things are now structured, well structured, to the extent that when you are a prosecutor, you concentrate only on prosecution. You are not given the opportunity to do any other thing except prosecution. And a position of a magistrate requires much more than that. Remember that prosecutors deal only with criminal matters. They are not given the opportunity to, as I did in the past, check work of clerk of the civil court. Some of them were never even appointed clerks of civil court. Like in the past, it used to be a progression, and we used to do rotation. This month you are in this office, next month you are in this office, next month the other office. As a result, a person who has worked in a magistrate's office for a period of 10 years, he will know almost everything about that office except a position of a magistrate, because that requires speciality. You must have a degree, you must undergo training, but for now, things are structured, and to a certain extent, they disadvantage other people. You will have to go and do civil work, you will have to go and preside over. It will be difficult, I believe, unless the system is changed.
Thank you. With the court you are in, one of the difficulties is the backlog because of the rationalization process being the court, that the court role is growing at a faster pace than the numbers of judges. What will your appointment help to manage that situation so that the court can run smoothly and people can access justice within that environment?
Honorable Minister, may I use this opportunity to plead with you to give us.
I'm asking you the question
to give
you the opportunity to.
Yes.
Yeah.
And may I use this opportunity to ask you to give us more acting positions so that we can have more acting judges. And remember that it's a succession process or process. Making people to act relates to succession process, because we are aging, we are going out. We must use this opportunity to train other people who will take after us. And also, creating more acting posts will also help in transformation of the division. Transformation in the sense that we will have more women. Yes, gender is very important. But over and above that, we will also have transformation regarding age. You will have older judges, we will have younger judges, as long as they are experienced enough. It doesn't take 20 years to get experience in doing the job. Give them the opportunity by giving us acting posts. Right now,
thank you. CJ, with your indulgence, last one on the same issue.
Yes, Minister, please proceed.
Yeah, on that point that you are raising, you are aware that I can only approve up until the establishment of the structure. So the challenge we have with yourselves and Mpumalanga now is that you want to also sometimes appoint beyond the additional to the establishment, which becomes a challenge because it's now a budget issue which requires national treasury, because I can't take budget decisions without concurrence or approval of national treasury. So that is the challenge that we are having because of the current rationalization structure that is there. So my question is, with the current situation and establishment that you do have, what do you think could be done to enhance access to justice within the existing establishment?
Our JP has already started with that, inviting people to come and act pro bono. without payment. And some are doing that, and they are doing excellent job. They are assisting the division in affording members of the community access to justice. And I was also thinking, that is my view, that if possible, magistrate must be given the opportunity on the same salary. Those who are prepared to do that, the salaries that they are already earning as magistrates, and then they're asked to come and act. It will only be those who are willing to do that, of course, but it will be done without extra costs because they are already on PESAL. They are earning, and they have been magistrates, they have been running courts, they will be able to assist, because in the first place, it is our customers who must come first. Our customers is members of the public. We cannot continue to have backlog on our roll. In criminal cases, where an accused person is in custody, yes, he is presumed to be innocent until he's proven guilty. But for that person to be in custody for 5 years, awaiting trial, because there are shortages of judges in the High Court, when we can invite regional court magistrates who are well equipped, they are well experienced in criminal. Remember that most of them do criminal matters, and instead of allowing those people to remain in custody for 5 years, only to be acquitted thereafter, and the reason being that there is a shortage, is an injustice. A lot of injustice. So I'm saying, if it is a question of finance, invite magistrates who are willing to do that job at the salary that they are earning now. And also advocates and other practitioners who are willing to do the job pro bono.
Yeah, maybe that is a discussion you will have with the JP and yourself in case as the current acting leader in the division, as to whether that is practical to be done or not, and then we can have that discussion at the outside this platform. Thank you, CJ.
Thank you very much, Minister. Commissioner Tsape.
ECJ. Good evening, Judge.
Good evening, Commissioner.
Thank you. When President Maya asked you the question to talk about the responsibility of a DJP, one of the questions she asked was, what are the challenges currently in your division? And what do you think, what would be your proposal to remedy those challenges at the time? It's similar to my question. Mine would be more streamlined, more to any challenges in relation to allocation of work or timeless delivery of judgments, if there are.
As I have already said, we are only 6 in that division, and it is most of the judges, I don't want to lie, they are hard workers. And with allocation of work, I always say, if you are a good manager, you will know who each judge is good at, and you will allocate him work in that section, knowing that he will finalize cases quickly. He will deliver his judgment within this period that is norms and standards, in terms of the norms and standards. And what we do is that we run three criminal courts, for instance, with the assistance of the JP, who will at some times ask us if we are overloaded, and he will take some of the files and do them. And for the speedy finalization of cases, it may happen that the role that you are having collapses. You don't just say my role has collapsed, I am not going to do anything. It is two courts, but we run them together. If my role collapses, I will go to the other judge to say, do you have a file that you can allocate me? We will continue to work in that fashion. Although it is heavy, I don't want to lie, but it's a division of hardworking judges. I don't want to lie, and we compromise, we work together in that regard.
Thank you, Judge. Thank you, CJ.
Thank you very much for this, Natsate. Advocate Kennedy.
Good evening, Judge. I have one short question, and really to rectify an error in the GCB's report. They indicate that you're 69 years of age, and that is the only reservation I have against your appointment. And I just wanted to clarify, my understanding is that you were born in 1961. Is that correct?
Yes, I was.
In
It's
other words, that
59, not
makes you
69.
older.
No, it's 59,
61. Oh, 59.
59 years, not
So it's not correct.
Sorry?
You were born in 1961.
1961.
Sorry, is it correct that you were born in 1961?
Yes, it is correct, Commissioner.
And therefore, as you sit there today, although you do not look your age at all, you are only 60 years old, not 69 years old.
I was born in 1961. I am 59 years old, not 69.
Right, thank you very much. There's a correction I want to make in your favor. Thank you, CJ.
Yes, I look young. Yes, it's a compliment. Thank you.
Honorable Malema. Thank you, Commissioner Kane.
Yeah, thank you, CJ. Sometimes we don't hear you from home, guys, so we hope you are in a better condition there. Now, the issue I want to canvass here with you, Judge. Good evening.
Good evening, Commissioner.
Given the background of our struggle in this country and where women come from, and there are two candidates. You've got a male candidate who knows digitalization, who want to digitalize the courts. And you've got a female with a very good track record, who interviewed very well, who writes very scholarly judgments with a proper managerial skills. What do you do, given the triple oppression of women? One, that they were oppressed as women. Two, that they were oppressed as working class. Three, that they were oppressed as Black Africans. And then you've got a male here who's an African who has had all types of privileges. The only thing different this time is that he knows how to press computer and he wants to put the files on computer. Which one should we go with?
A woman, of course. One other thing is that we admit many women, but you don't know where they end up. And if you appoint a woman, you will encourage those other women to, it is doable, come and do the job. There is nothing scary about it. And if you keep on giving women an impression that this is a man's job, we will never rectify this thing. Some of us we have just to smile. Should it appear to them, especially the youngsters, that this is a job for only where older women are appointed? And what I do most of the time is that during admissions, I encourage women to come in, to continue, not to get admitted and go and stay home. Come and do the job. You are better suited to do this job. We actually wear many caps. Different caps. You take this cap, you put this one, you take, women are capable of doing that. And with the digitization, I am busy with Judge Khanyago. We are doing directives where we will work digitally. We are in the procedure, will very soon be part of us as well.
I'm happy you dealt with it because I wanted to ask you if will you be able to lead this process of digitalization of cases, but I'm happy you are
No, we
busy
are
with
busy with
Judge
it.
Khanyago. So it means you've got everything, a woman disadvantage, even with digital. Thank you.
It is also important. Digital is also important, especially now because we have a local division. It will help us when we hold meetings. Rather than for them to travel 200 kilometers from Toando to the main seat, we can do it by Zoom.
Thank you, CJ. Good evening. Yeah, to your right. Good evening, ma'am.
Good evening,
It's
Commissioner.
nice to meet you. I have just one question for you, and that relates to some comments that were made, and you had asked about it when you were appointed. Then the BLA had issues about they thought you didn't have enough experience and needed some additional acting stints, but you were appointed. Now I also read that in the society, the Limpopo Society of Advocates, they write that they do not think that your legal knowledge is enough for the position that you are shortlisted. Would you mind to comment on that?
They are citing cases where I was set aside by the appeal court. It is the nature of the job. Some of your cases will be confirmed, others will be set aside, and it's a learning. We are learning, and I don't know whether I must address one of the matters that they referred to as an example that I cannot do. My legal knowledge is lacking. Is a case which went on appeal, where one judge agreed with me, 2 other judges didn't. It means it's 2 against 2. Are they also saying this other judge's knowledge of the law is also lacking? And there is this other case, which according to me is that they cited as an example, which according to me is we were set aside. We were criticized, I agree, by the Supreme Court of Appeal. They criticized us on the approach. But the position in that case was that it was an appeal against sentence. It was a gruesome murder. I agree, it was a very gruesome murder. And it was an appeal against sentence. I agreed that the sentence of the court should be confirmed. And my reasons are, it was a gruesome murder of 4 children. It is well known. It was also an assault on their mother. The court imposed a sentence of 82 years. But effective sentence was to be 52 years. I considered life, yes. I considered life imprisonment because according to Act 105 of 1995, it fell under that category. But I looked at the nature of the crime and I thought if I change that sentence to life, that is my view. Unfortunately, the Supreme Court of Appeal did not agree with me. And I thought about life and I said, if I change this sentence to life, he's effectively going to serve only 25 years. So a suitable sentence, according to me, was a sentence which is longer than 25 years because of the heinous nature of that offense. And that is why I agreed with my colleagues that 52 years is the most suitable sentence under the circumstances of the case. I humbly, let me say, yes, we were found to be wrong. And it is, as I said, the nature of the game. I don't believe that there is any judge who has never been set aside on appeal. And if I don't agree that because of those examples, I lack knowledge of the law. And in other cases, 3 judges set me aside on appeal. And the appeal court agreed with me and said they are actually wrong. I am the one who's correct.
Thank you, Judge. Thank you, CJ.
Thank you, Prof. JP Mlambo.
Thank you, Chief Justice. Good evening, Judge Semenya.
Good evening, JP.
Just to set the record straight, me, you, and Judge Patudi were in the same class.
Yes.
Thank you.
And you are JP already. We are still.
Well, in response to that comment, is it not correct that after university, we only met at the case flow management committee where I met you, and that's when your acting stint started?
And I thank you for that.
Well, I'm just responding to your comment.
Yes. You walked past me, it was raining, and you walked past me, and we attended that case flow meeting. And as you were addressing me, you said, no, we were in the same class. And I said, yes, we were in the same class.
Okay, thanks for that. I just want to ask you a question I've asked the other candidates, just for fairness' sake. Do you subscribe to the view that as a leader in the judiciary, like you want to lead a division, you want to be the deputy judge present, that you've got to be administratively and managerially astute, that you need to have good skills in those fields, as well as being a good jurist to sit in court and write judgments as well, to lead in both fields? What's your view to that?
I agree that you need to have both. Otherwise, the division will collapse.
I'm happy you answered that way. And are you able to share with us any of your judgments that went to the SCA or Concord that were confirmed there?
Yes, this is the one that I referred to when Commissioner was asking me.
Yes. Okay.
It was a section 15 of the Matrimonial Property Act. And it was a case where a spouse sold an immovable property to a third person without the knowledge of the other spouse. And the spouse came to court for the court to set aside the sale because that was done without the consent of the other spouse in terms of the act.
So were you upheld in that judgment?
I beg yours?
Were you upheld?
Yes, I was upheld.
Okay, no, that's what I wanted to know, by the Supreme Court of Appeal.
Yes, I was upheld.
Yes. Thank you very much. The last question is, I know that the regional magistrates out there are cursing me, but I sit in the PEC. And the biggest problem in the PEC is that in the regional court, and some high courts too, but mostly in the regional court, there are trials that never end, that last 5 years, 6 years, 7 years. We track these statistics, and there are backlogs. As a leader in the judiciary with the responsibility in terms of Section 8 of the Superior Courts Act, what do you think we can do? What do you think you will do if you are appointed? Because you will have that responsibility.
8 years is too much. And there must be an explanation why this matter cannot be finalized in the first place. He must be called and he must explain. That is what case flow is all about. He must explain, he or she must explain what is causing the delay in finalization of that matter. And if I can assist, or there is a way in which I can assist, because sometimes you find that witnesses just don't come to court. Or one witness will come the next day when he's supposed to be cross-examined, he fails to come. And this is where it is important to get engagement of all stakeholders, because as the GJP or as the head of court, you are the first person who can work in close contact with the commissioner, station commissioner. And you can bring it to his attention that the magistrate is unable to finalize this case because your investigating officer is failing to bring witnesses to court. But as I say, it will depend on the reasons that that person is giving you.
Yeah. Okay, thank you. Thank you very much, Chief Justice.
Thank you, Judge President. Honorable Kaba.
Thank you very much, CJ, and good evening, Judge.
Good evening, Commissioner.
It's on a lighter note, Judge. Are you, as a prospective DJP, do you subscribe to democratic values?
Yes, I do.
How come you have been in the same leadership position in the Anglican Church for close to 20 years?
It is always the case where there is no remuneration.
Oh, thank you so much.
Thank you very much, Judge Semenya. You are excused.
Thank you, Chief Justice.
Colleagues, I take it we need a 5 minutes break to reassemble for the purpose of deliberations.
Okay.
Chief Justice, the candidate is ready.
Thank you. Thank you very much, Judge President Lambo. And let me take this opportunity to welcome Judge President Benanga. JP, I welcome you.
Good evening. Thank you, CJ.
And also to welcome Honorable Premier Mabuyani. I welcome you, Premier.
Thank you very much. Good evening, CJ, and good evening to all commissioners. Thank you so much.
Thank you.
Hey, Chief, we're looking for you here. We can't see you.
No, I'm here. I'm here. You can see
Oh,
me.
yes. You're supposed to be here, physical.
Thank you so much. Okay.
Good evening, Advocate Bugara SC.
Yes, good evening, Chief Justice, the President of the SCA and the Commissioners.
How are you, sir?
Yes. Pardon?
How are you?
I'm all right, Chief Justice.
Yeah. Very well. Let us start then. You've made yourself available for the position of judge, and you are the only candidate.
Yes.
Are you ready to tell us a bit about why you should be considered for the position?
Well, Chief Justice, I have practiced as an advocate for 30 years, and I believe that I have accumulated a considerable experience for this nomination.
So you have a lot of experience, and there is no impediment to your appointment.
Well, Chief Justice, I have not received a letter of approval from my organization, that is the Johannesburg Society of Advocates. And seemingly the application is defective in the absence of that recommendation. All what I can say is that I have made considerable efforts to persuade those involved in my organization to give me the recommendation. The complaint against me was brought to the attention of my organization in September last year. And then in December, towards the end of December, my organization sent me the complaint for responses, and I finished responses within a couple of days. I had received the document from my organization. And thereafter, I kept on and on and on appealing to my organization, starting with the chairperson of the Professional and Fees Committee, and ultimately to the chairperson of the Bar Council, to no avail, until the 6th of this month. I wrote a letter to the chairperson of the Bar Council to treat the matter with the urgency it deserves, and furnish me with the recommendation, or charge me if there's that option, or at least explain to this commission the reason why the recommendation cannot be furnished on my behalf. Then all what I received was a letter dated 8th of this month, asking certain information, which is part of the information already in possession of my organization. That is what I can explain, Chief Justice, about a defect in my application.
Now, in the absence of clearance from your organization, what are you saying we should do? What should we make of it?
Sorry, Chief Justice?
In the absence of clearance from your own organization, what then have you decided to do, and what should we make of that situation?
No, I don't believe that this commission can entertain my application in the absence of a recommendation from my organization. And
all right, what then have you decided to do if you have taken it?
well, if I were in court, I would say I'm withdrawing my application, Chief Justice.
Thank you, sir.
All right, okay.
Chief Justice.
Yeah. But I think we need a clear answer. If you were in court, now that you are here and not in court.
Well, I am not in court now, Chief Justice. I'm unable to pursue the application in the circumstances. Okay. I can raise it at some later stage given an opportunity.
Thank you very much, Advocate SC. You are excused.
No,
Thank you.
Chief Justice, can I, before he gets excused, it's Matoro Lepo, I'm a bit concerned that Advocate Dukata is speaking about the clearance from his organization. As far as I know, the LPC has to clear you.
What, pardon?
The Legal Practice Council has to clear you. Your organization can recommend you, not clearing. The clearing comes from the Legal Practice Council.
Well, is that a question?
CJ, they will talk outside.
Pardon?
Colleagues, my understanding is that Advocate Dugata is removing himself from us. Do we want to keep him here?
No, thank you. Thank you, CJ. Good night.
Yes, thank you.
Thank you, Advocate. Thank you, sir.
Thank you, Chief Justice.
Thank you. Bye-bye.
Chief Justice?
Yes, Honorable Singh?
Yeah, as he leaves, I don't know if we can have the attention of the JP of that province for 2 minutes.
What about the Premier?
The JP and the Premier. I mean, the question that President Meyer responded to was that they didn't have any applications. I did worry that only one candidate will come through for that. Perhaps we need an explanation. Thank you.
The media is still
all right, I take it that you would prefer that we clear the room for that meeting.
Yes.
Yes.
Thank you. If members of the media and the public would please be requested to leave the room or the platform as the case may be.
Well,